All right, good morning. This is the Energy and Carbon Management Commission. This is our weekly hearing. It is April 3rd. It is 9:01. We are all here. Let's recognize that fact with a roll call.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Oath? Commissioner Ray?
Here.
Commissioner Robbins?
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Great. Great to see everybody. We will first talk about our agenda. Hearings Manager Thomas, do you have any comments with regard to that?
Thank you, Mr. Chair. Yes, with regards to the consent agenda, the hearings unit will be pulling docket number 2401-00002, Karis Piance variance. That, due to an oversight, that was put on the consent agenda without receiving a director's recommendation. So we will hold that until the director's recommendation is issued. So apologies for that oversight.
All right. Excellent. Consent agenda is modified. Before we get to consent, we have commissioner comments. Any comments from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Just an announcement that the next monthly Colorado Produced Water Consortium meeting will be held this Friday at 9 a.m. It's a virtual meeting. Public are able to participate. And if you want more information about that or would like to participate, there's information on the Produced Water Consortium website on the DNR page.
Excellent. Thanks for continuing to galvanize that cause. Other questions or comments from commissioners? All right, we'll move to consent agenda as modified. Does anyone have questions or do we have a motion?
I'll move approval of the consent agenda.
Second. Motion and a second to approve consent. All those in favor signify by saying aye. Aye. Any opposed? The consent agenda is approved. All right, we will turn to our first docket, 2211-00286, a financial assurance plan, Evergreen Natural Resources, LLC. Procedurally, Commissioner Messner, would you like to speak a bit about your getting up to speed?
Certainly, Mr. Chair. I was away for the March 27th meeting. However, I've reviewed all the docket information and have viewed the YouTube video of the March 27th hearing and prepared to participate in the continued hearing this morning.
Very good. I think that's satisfactory. AAG Davenport, could you elevate yourself and give us your perspective as our Attorney General?
Thank you, Chair. Thank you, Commissioner Messner. As Commissioner Messner stated, he's reviewed the entire hearing and the docket, and that's adequate and sufficient for him to participate as a voting member of the commission this morning in this matter.
Very good. All right, I see that we have Mr. Martin and Mr. Lepore with us. Could you first introduce yourselves for the record?
Good morning, Chair Robbins. Jim Martin of Beatty Wozniak, representing Evergreen Natural Resources.
Good morning, Mr. Chair and Commissioners. My name is Matt Lepore, Insight Energy Law, also representing Evergreen Natural Resources.
All right, thank you very much. Procedurally, you heard from Commissioner Mess that he's fully vetted himself with regard to the record. Any concerns on that front from your perspective?
Not from me, Mr. Chair.
Seeing Mr. Lepore nodding his head in a negative, a non-positive fashion, he's okay with it too. Is that right?
That is correct. No concerns.
All right. Are you guys ready to rock and roll here?
Mr. Chair, we are, and we have a preliminary procedural matter we'd like to raise with your permission.
Please do.
So I understand it. Staff has placed in your packet a letter from an interested person regarding this application. We would like to ensure that that matter is expunged from the record, and if necessary, we're prepared to make a motion to strike. Happy to give you the bases for those objections.
Yeah, no, I appreciate that. AG Davenport, if you could visualize yourself once again, I believe offline we had some discussions that that matter would not be part of the record. Can you elaborate?
Thank you, Chair. I think we're all referring to an email communication from a member of the public that was sent, I believe, yesterday. In my view, it is not appropriate to include that public comment in this record. It is untimely. It was submitted after the commission had heard from the operator in this case, after the time set aside for public comment. And I think it's consistent with the commission's practice to not accept public comments that are late filed in this manner.
And just to elaborate just a bit there, AG Davenport, what's the basis for that consistent application of our rules so that the proponent of the email is not chagrined that it's not being considered?
The basis is that the commission sets aside time for matters for public comment, and the practice is to hear that public comment before the parties are heard from, so that the commission has adequate time to consider it and the parties have time to respond to that comment if they so choose to do so. In this case, there was time set aside for public comment on March 27th in advance of hearing the merits of this matter. And the public could have filed a written public comment in advance as well. At this point, commissioners have only had less than a day to consider that public comment, and parties haven't had a chance to respond to it. So that's the basis for not accepting comments that are filed after party presentations and after the time set aside for public comment. I would also note that means, should the commission agree with me that the comment will not be included in the record and the commission will not consider it in its deliberations on this matter.
Yeah, and the proponent of the comment, Ms. Merlin, who we all know is aware of these rules and regulations and procedural efficacies. Am I correct there?
Well, certainly, I think anybody who's viewed commissions knows about the commission's practice, knows when the commission accepts public comment, knows that time is set aside for public comment, and should know about our rules in regard to public comment. To answer your question specifically, I don't know that there was any direct communication with the commenter about this specific comment. Yes, yet.
All right. Well, I'll note for the record that Ms. Merlin is a practicing lawyer. She represents Wild Earth Guardians. She's aware of our procedural rules. She's practiced before us. We always appreciate hearing from her and her client's perspective. And in this regard, we will strike the comment from the record with all of this having been said. Mr. Martin, is that satisfactory?
It is, Mr. Chair. Thank you very much.
All right. Any other procedural matters before we turn to the merits?
No, Mr. Chair.
All right, then I think where we were is Commissioner Cross was having some questions for the applicant and the attorneys. So with that, I would look to Commissioner Cross to continue with regard to his questions. I would remind everyone that we've already had the kind of case in chief presented, and we are in questions from commissioners, which would then be followed by deliberations. Commissioner Cross.
Mr. Chair, if I might add, I believe Mr. Joy also has had an occasion over the course of the last week to give Mr. Cross and Commissioner McGowan, sorry, not enough coffee yet this morning, give their questions some greater thought, so at an appropriate time he may be able to further elaborate on his response to questions from those two commissioners and others as well.
Well, I don't have any problem at all in allowing Mr. Joy to start us off here. If he's got additional thoughts and considerations with regard to questions already posed, that might do a good job of kind of teeing off this morning's discussion.
Thank you, Mr. Chair. I'll turn it over to Mr. Joy, who I believe has already been sworn in.
Yeah, Mr. Joy, we'll just remind you were sworn in to tell the truth and all that jazz before. So we look forward to hearing from you.
Of course. Thank you, Mr. Chairman. Good morning, and I want to again thank the commissioners for the opportunity to continue what I think is a pretty important discussion. I'd like to detail and hopefully clarify some of the asset retirement plan issues that we were discussing, particularly with Commissioners Cross and McGowan last week. So following the questioning from last week, I worked with my staff to gather some further information on Evergreen's asset retirement plan evaluation process, and more particularly to be able to articulate exactly how Evergreen evaluate wells for plugging and abandonment. I want to first reiterate that over the operational life of the field, Evergreen and its predecessors in interest, which of course includes Evergreen 1, have plugged, abandoned, and reclaimed over 200 wells. And this Evergreen has provided now substantial demonstrated reclamation cost data on reclamations performed by this Evergreen during our period of ownership. I'm not aware of any of it adverse compliance history related to orphaned or unplugged wells. And to the best of my knowledge, Evergreen is in compliance with the plugging and abandonment requirements of ECMC Rule 434, which of course exists specifically to regulate the plugging and abandonment process. I think a little bit of background on the field operations is really relevant to the issue. As was discussed at the initial hearing in August at some length, Evergreen's coal bed methane operations in the Raton Basin differ from conventional production, and now the most common form of production, which is coming from relatively deep shale wells. It's not to say that we're special, it's just to say that we're different. In conventional production in shale wells stimulated with high volume hydraulic fracturing, each well essentially drains its own reservoir, and each well is economically and productively standing on its own. So by way of example, if I were to drill a well that I call the Lapour number 1, and a mile down the road I were to drill the Martin number 1 today, those wells would economically stand alone. And the Lapour number 1, when the Lapour number 1 dropped below an economically productive volume, it'd be subject to plugging and abandonment. The same would be true of the Martin. And there wouldn't be much relationship between those wells. That's the most common circumstance in the oil and gas industry today. In the case of the coal bed methane production, it's different. The entire field acts as an integrated system. So each well that is drilled into an essentially a common reservoir, and each well both impacts and is impacted by the adjacent wells. The reservoir is in equilibrium, and it declines at essentially a consistent rate over time across the entire field. So Evergreen's previously provided, I think, relatively extensive data and testimony on the low decline rate of the field, but I want to update that a little bit. In 2023, our field declined at a rate of less than 2%. And thus far in 2024, we've seen a 0 decline rate across the field. And that's the effect of our restimulation program at work. Not only is our reservoir in equilibrium, but each of our wells produces into an integrated gathering and compression system, which is also owned and operated by Evergreen. And the entire gathering system is interconnected. In our case, it's technically called a loop system, such that all of the compression op stations have an impact on all other compression stations field-wide. So unlike most operators, ENR operates a common and interconnected subsurface reservoir that produces into a common above surface reservoir. And those commonalities are the driver for why Evergreen's wells can be economic at such low production volumes. We operate the system as a whole, not based on a collection of single well economics. So to do that, we're constantly evaluating the economic and the operational capabilities, which means we're also constantly evaluating plugging and abandonment wells. It's just that the criteria that we use are somewhat different than you might be accustomed to for a conventional or a shale well based on single well economics. So for us, there are 2 component parts to how we evaluate the economics of a well. And then there's a third component, which I'm going to mention, that's really used just in evaluating plugging and abandonment. To determine well economics, we first evaluate the flow rate of the well. And as Wayne Burton from NSAI testified at some length, our wells can be economic at flow rates as low as a quarter of an MCF equivalent a day. But the other component that we use is the remaining reserves left in the reservoir to be produced. So there's one component, which is just production rate. And there's a second component, which is the remaining reserves that can be produced from a well or our reservoir if it's re-stimulated or the well is re-equipped. To address Commissioner Cross's question, the low producing well criteria used in the regulations for financial assurance only takes into consideration really the rate. It does not really seem to contemplate the remaining life of the reserves that we have. So as we evaluate the future production potential, that means as we evaluate the reserves, we look at the engineering runs to determine how much initial gas there was, how much has already been produced, and what's the volume of the reserves that remain behind pipe. And just to give you some economic examples, a well with just 1/10 of a BCF of our reserves remaining behind pipe, I mean, we've already discovered them, we've already put the well in, we've already had it in production, it's sort of sitting there to be produced. That well becomes economic to do a full nitrogen foam refrac, which you heard a lot about last fall. But a well with just 1/10 of those reserves can be economic if we're going to do, for instance, a pressure pumped acid job, and even less if it's a mechanical issue like a pump change or a tubing change. So we evaluate both flow rate and remaining reserves. And that means that our wells can be really economic even at low flow rates, because if the reserves are there, the well is just going to produce at a relatively low rate, but over a very long period of time. So I checked for compliance as recently as yesterday evening at the close of business. And when we started the year, Evergreen had 51 wells that were either shut in or in temporary abandonment status and subject to a mechanical integrity test under Rule 434. And that was frankly just the easiest sorting mechanism I had, as we keep a specific inventory of those wells. And out of those 51 wells, which are 51 of the total portfolio of 2,236, so a relatively small number, 16 have already been evaluated and subject to an MIT, all of which have passed. So all the wells have maintained their mechanical integrity. 7 have already been returned to production. 2 have equipment issues in hole, which we'll have to address. So basically, we stuck a tool during a re-stimulation. And 7 have been added to our re-stimulation portfolio. We have 35 additional wells to do, again, out of the portfolio of 2,236. And in our experience, about 50% of those are going to be returned to production, so converted from shut-in or T8 status back to production at the time of evaluation. It's just a surface equipment issue. So in our case, 16 to 18 of those wells will be added to our re-stimulation program. For context, we've already done 51 field re-stimulations of all kinds already this year. We've got 39 planned, and on average, we do between 180 and 280 field re-stimulations of all kinds, or about 10% every year. Consequently, even if we had to add all 51 of those T8 wells to our re-stimulation program, it's still only 1/5 of what we were planning to do and would do this year everywhere. Anyway, so this is again not to say that Evergreen does not intend to plug or abandon or reclaim locations ever. That is not my position, and it's never been my position, and it's simply not true. Again, we've already, in our predecessors, we've already done 200. But it is unusual that I think that operator comes before you that actually does field re-stimulation on 10% of its inventory of wells every year. The third criteria that we do have to look at, and I said I would discuss, is actually the leading criteria that we use to evaluate whether a well needs to be plugged or abandoned. And it's not remaining reservoir life, and it's not production rate. It's actually a mechanical issue. So if a well can't be stimulated because of a downhole issue, and those types of issues are things you know about. There's cement degradation, or loss of circulation, there's a mechanical failure of a wellbore. Evergreen can and will, and our predecessors certainly have plugged and abandoned those locations, and we'll do that consistent with consistent with ECMC Rule 434. But with such a large inventory of wells, it's both common and I think it should be expected that any given day, wells are going to move into the low producing category, and other wells are going to move out of the low producing category, depending on where they are in our well re-stimulation program. We evaluate that on a constant basis because we're doing several hundred each year. So just to summarize, in compliance with Rule 434, Evergreen will plug and abandon wells in the ordinary course of business when the following criteria are met. When a well is incapable of commercial or operational production of gas or water, when there are no remaining producible quantities or reserves, or when there's a mechanical well or a well integrity issue that exists that can't be economically rectified and such that the well has to be plugged or abandoned. We do that all in compliance with existing rules, and I think that probably best articulates our asset retirement plan. Mr. Chairman, back to questions for you, please. I think.
Yeah, how, so lots of words there.
Yes.
How do those words find their way onto a piece of paper that we can act upon relevant to the retirement asset plan? Because the retirement asset plan paper we've got doesn't really articulate those sorts of things. And so parts of the discussion between Mr. Cross and Commissioner McCowan were some anxiety around that point. And I'm not trying to put words in either of my fellow commissioners' mouths, but I think that's probably the first thing they would say.
At some point, I'll turn it back to Misters Lepore or Martin to articulate the guidance that we have on asset retirement plans from the statement of basis of purpose, or the requirements that we have. But what we did was, frankly, we looked to the types of asset retirement plans that other operators were submitting to try and say what I just said, which is there are regulations that govern when a well has to be plugged and abandoned, when it has to be shut in, when it's in temporary abandonment status, what you have to do. And we comply with all of those. Again, to the best of my knowledge, we're in full compliance with all of them. I think we tried to say that in the asset retirement plan that we submitted. If we fell short of the words, I guess I will both apologize and say I'm not sure that I would have gotten it any different based on the guidance that we had. So if what's required is revisions to the asset retirement plan to be consistent with what I just said, we're of course happy to do that.
Commissioner McGowan, I'm going to put you on the spot. This was your line of inquiry to begin with. Do you want to ask any further questions here?
Thank you, Mr. Chair. I think what I'm struggling with, essentially what I hear you saying is the endpoint is so far away. Just trust me, I'm going to re-stimulate, and I'm an operator in good standing, and I will plug my wells when it's ready and time to plug them. That's what every operator is supposed to be doing. And you're also supposed to have an asset retirement plan that shows us that you're setting aside resources, even if the endpoint is way, way down the line, and you have something to show the commission that we're not going to be left holding the bag if and when you leave, when the wells are done, they're all covered. And I don't see that here, and I don't see that with those words. And so that's what I'm struggling with.
Mr. Chair and Commissioner McGowan, if I may. So I think that we, Evergreen, and perhaps a broader segment of the industry also struggle with what you are looking for in the asset retirement plan. So after last week, I went and looked at the statement of basis and purpose to see what it says. And I'll read you what it says in its entirety. When reviewing an operator's asset retirement plan, the director will examine an operator's reason for maintaining inactive wells and the timing of the operator's plan to retire assets. Then I went to see if there was guidance from the commission on this subject. And there is a financial assurance plan guidance document. And with respect to asset retirement plans, it simply quotes the statement of basis and purpose. So the sum total of guidance we have is that sentence that I just read you. So I honestly believe what we have tried to do twice now is tell you how Evergreen views the timing of its plan to retire assets. It is a long way off. They are paying attention. They do have a process. but it's not like there's an expiration date or the warranty runs out on, or, you know, wells are good for 20 years and 10 months. It's just not that precise. And that it feels like that's what you're asking for, and maybe you're not. But we cannot seem to hit that mark. And we're really struggling with what else to say to you, except this is how the field works. This is why it's economic at very low producing volumes. And with respect to the question about setting aside resources, or that you're not going to be left holding the bag, that's what the surety bond is for and does. And that's also what your ability to review this plan periodically allows you. It is also what Evergreen's ability to update its plan periodically, as wells come off, go on to the inactive or out of service list or the low producing list. There is a lot of runway here, which we think is relevant. So I guess I'll stop there. We think we have, well, we've done our best. I don't want to say, I mean, in the spirit of a conversation, which, by the way, doesn't take place in front of the staff. They just don't seem to have the resources to have a back and forth kind of conversation with us about this. We're doing our best to show you that this operator has a plan to retire its assets in a timely fashion, pursuant to the guidance and pursuant to the rules.
Commissioner McGowan?
Thank you, Mr. Chair. And I thank you, Mr. Lepore. I appreciate your perspective. I am uncomfortable with a narrative of my well's lifespan is so long that this kind of my asset retirement is I'll plug them when it's time to plug them. That's what every operator would submit then. And I don't think that's really what we meant. And I don't think if you've listened to other financial assurance conversations with operators, that for me as a commissioner, that's my expectation for an asset retirement plan. So I will stop there. I think we understand each other. I think we perhaps disagree. I feel like there's a lot being said about our staff and what they think without our staff actually telling us what they think. We've not heard from them. At some point, I guess I would like to hear from staff and their perspective, because they also didn't feel that this second go around was perhaps adequate to meet our financial assurance requirements. So, Mr. Chair, at some point, I guess I would like to hear from staff and their perspective as well.
Yeah, very good. I see that we have Director Murphy and Scott Cuthbertson on the call, so we'll get to them in a bit. Commissioner Cross?
Thank you, Mr. Chair. I want to, and I think it might be appropriate to talk about some of the details of reclamation issues later on. I do think it's prudent to talk about the asset retirement issue first. And I think one of the things that really sticks out to me, similar to Commissioner McGowan, is right now, the asset retirement plan as listed, as we talked about last week, simply says ENR will timely plug and abandon wells that do not merit field restimulation and are not contributing to economic and operational production in compliance with rules. And I think, to me, one of the things that I sent in the interim was hoping to get some kind of information, and I'm not looking for public disclosure of any kind of confidential business information, but I think it would be appropriate to get some kind of information showing what, if any, baseline Evergreen has for that determination. And to provide an example, I know many, if not all, I would presume all, but many operators will look at a field, will look at their different productions and say, at this level, at this assumed price, we can make money. Now, I fully understand, Mr. Joy, what you're saying, that there's another layer involved in the coal bed methane drilling, because you're looking at an entire field and dewatering and everything else. But essentially what I'm hoping to understand is, does Evergreen have a set limit that says we can operate efficiently at X MCF per day? Yes, that may be above 2, that may be below 2, but saying, when looking at this field, looking at this well, if it falls below this number, is there something that we can point to that says, even though it's below this number, it is still important because of the dewatering, because of what else it's doing to the field? Now, one of the things that was talked about last week, and I talked about the 3 years, fully understanding our rules and everything else, but we talked about every 3 years being able to provide this kind of information and update it. And you said, well, really, we're looking at it every single day. And you said, in fact, we're already giving stuff to staff every month so they can look at it. Now, there's also tens of thousands of wells in our state, and our staff doesn't have the capability to look at tens of thousands of wells of production information every month and say, well, let's look at Evergreen here. They're trying to define their low producing as 2 MCF. This one's at 1.8 MCF this month. So why don't we have some kind of information? We simply don't have the capabilities, the funding to do that kind of information. And so really and I'm not saying how it needs to be done or anything else, but more than saying we will plug and abandon if it's not economic or operationally beneficial. Saying, all right, we've under our option 5 plan, we're saying it's still beneficial for us to maybe be less than 10 MCF. That 2 MCF is maybe where it starts to become problematic. But what I'm looking for is something to say, we are ready to plug and abandon if less than 2 MCF, and it doesn't necessarily have to be that, so long as this well also does not provide this operational capability, et cetera, et cetera. It falls below whatever, maybe as long as natural gas is at $2, we can operate this well as long as it's producing X amount, something like that to connect it. That, because, I appreciate Mr. Lepore reading everything to us, but when you look at what it talks about asset retirement plan in our rules, a demonstration of how the operator is planning for the retirement of its oil and gas operations based on the projected life of the field, age of the infrastructure, out of service, inactive, low producing wells, related information. And really all we're being told is, well, if it's not beneficial, then we'll plug it. That says nothing about, I again appreciate the information that you provided last fall with respect to the potential life of the field. But this is talking about, what is your plan based on the age of your infrastructure, based on the life of the field, based on all these different aspects? How do you eventually plan to start to move things to retiring those assets? And all we're hearing is, well, plug and abandon if it's not beneficial. And I feel like I fully understand that there's a lot of leniency, a lot of leeway in how things are provided into the state. I feel like with a lot of our rules, there's a lot of leeway given into how to distinguish that. And to a certain extent, it's going to vary from operator to operator. But I think saying we'll comply with the rules by plugging if it's not beneficial is not a description of how you plan to move towards the eventual asset retirement. And so that's the kind of information that I would love to hear is, again, I don't want you to publicly disclose any kind of proprietary information on operations or anything else like that, but an understanding of, if it's less than this amount, we have to start looking at, do we re-stimulate or do we move it into a plugin? And I know there was a lot of discussion last week about comparing to own resources. And a lot of what we saw with the own resources is it becomes uneconomical for us if it's less than 2 MCF a day. And so at 2 MCF a day, we will either have it in a re-stimulation schedule. I don't remember the exact words they put, but they talked about it will either be re-stimulated or it's moved to a plugging and abandonment list. And so that at least provided us with some kind of information that says, at this level, one of two things is going to happen. And we had it updated more often. And so that, I think that's one of the things that I would love to see here, because I do agree that Evergreen is in a fairly unique situation, just as I think Own Resources was in a unique situation. I don't think that, you know, any of the other buckets necessarily fits Evergreen. And so I do think an option 5 plan can be workable here. But I think the level of information that we have with how to move forward is not really provided here. And just kind of saying, when it's necessary, we'll plug and abandon it, isn't really talking about how it's going to be retired. It's not providing us any kind of clarity in Evergreen having a plan of, again, I don't need to schedule, we'll plug this many this year, because there may be years where you don't need to plug anything because of re-stimulation purposes. I don't need that kind of specific schedule. What I'm looking for is saying, we have thresholds established. We have a way to say, yes, this one is less than 2 MCF, but it is not moved to a plug-in and abandonment list because of the dewatering it does in the field for these other wells, and that helps them stay above 10 MCF or whatever the case may be. I just don't see any kind of information like that. We have had some asset retirement plans that have been filed confidentially before us, and I think some good, some bad, some didn't, again, also did not provide any kind of real information on what they plan to plug and abandon, but instead talked about the life of the field, that kind of information. But I think ultimately what I'm looking for as a commissioner is some kind of understanding of, we have taken the steps to say, these wells are productive for us, whether that's economically productive, operationally productive. Here's the threshold at which that changes. And that's when we start to look at whether it should be moved to a plug-in and abandonment list, whether it should start to be reclaimed. And I think that's also what the people of Colorado would want to know as well. Not, well, when it moves across this line and it's not productive, you'll know because it's all of a sudden going to be on a plug-in and abandonment list, when we have no idea what that trigger point is going to be. So I realize that was more of a statement than a question, but I kind of like to hear your thoughts on that.
Candidly, Commissioner Cross, I'm not sure how to respond, because I think that we endeavored to provide a lot of that information. I can't change the fact that and I don't want to, by the way, that the field, as you know from our third-party engineering reserve professionals, has a 35-year life. That's very different than I suspect many of the other wells that are currently drilled in Colorado and the people of Colorado are familiar with. But nevertheless, that's the case. My field has a 0 decline rate this year. That's almost unprecedented. Had a 2% decline rate last year. And so that 35-year life of the field essentially went unchanged. Because we don't do single well economics, because that's not how the field operates, our wells are economic at virtually any producing volume, because there is no incremental change in our costs for any well that is currently producing. So in other words, if I take a well offline today, there is no corresponding reduction in our field operating costs. That's a very unusual, I admit, set of circumstances. Nevertheless, that's our case. As I looked yesterday, I see one well that has a mechanical integrity issue. And as the weather's warming, we're preparing to do a cement squeeze job on that particular well, because it's actually quite productive. But if that weren't feasible, for example, that would become a well that would be subject to plugging and abandonment in 2024, actually. So if it's not done, if it's not successful, that well will be plugged. Those are the kinds of criteria that we have. I am truly sensitive to the request for how are you going to do this. We're going to do most of that years into the future. Not because I'm trying to delay it, but because that's frankly the business model of operating the tail end of wells that have a life expectancy as long as we are. If you have producible quantities of gas and you have producible quantities of gas behind pipe in reserves, and you plug that well, for the entirety of my career, that would have been considered waste and frankly, both in violation of public policy and law. So that's where I sit, is when I evaluate a well on its ability to flow and whether there are reserves behind pipe, I view our obligation to produce those resources. I think what you're trying to get at is there a point where I can say to you, when a well is below whatever flow rate? In our case, it wouldn't be 2 MCF. It would be virtually any flow rate, again, because there's not a cost of operating that well for us that would change. So that's really not a criteria that we would use. It's whether or not there are remaining producible quantities of reserves. I could redraft our asset retirement plan to say that, if that's responsive to your question, when there are not commercially producible quantities of reserves. I'll have to ask our engineers if in fact we can project that into the future. Maybe, I don't know. I've never seen it done that way. That would be new and novel to me, but it's possible, I think, and we're happy to look into that. You can certainly say that when there is a mechanical issue or some other factor that makes it uneconomic to be productive, we would plug an abandonment, and we have. And so, we do have a compliance history, I think, that is relevant. I do feel a bit like I'm, understandably so, sort of fighting against my predecessors who are no longer here, in part because they said things like, we'll never plug and abandon a well. That's not true. These wells do have a life. It's just that at very, very low volumes, they have a very long life. So again, I'm not sure I'm being responsive exactly to your statement or question, but I appreciate the conversation, because we at Evergreen are trying to understand what the commission is looking for and how to be responsive to you, given the I wouldn't say unique, but certainly different nature of our wells and our production.
Well, and a couple things stick out to me in the response that you just provided. And one of those is talking about if there are mechanical integrity issues that would go on. But that's not anywhere in the asset retirement plan either. And so really what we see here is just, if it's not beneficial, we'll plug it. And so even that level of detail, I'm not seeing in the asset retirement plan. And one of the other things is even the discussion of, as long as there are economically producible quantity of reserves. And so I appreciate that as well. And again, I'm not looking for a schedule necessarily. I'm looking for trigger points. But for the trigger point in your asset retirement plan to be, we'll meet the rules, is not really a trigger point, because that, frankly, it renders the asset retirement plan and that portion of the rules meaningless. It's superfluous to say, we'll meet the rules when you already have to meet the rules. And so even with what you just said there, it is more information. We're going to update based on mechanical integrity. We're going to, and I think one of the things that, again, sticks out with me from what we discussed last week as well is, well, we're going to update it every 3 years. And I feel like this is information that one of the things I will ask for, depending on where we are, is something more than every 3 years. Because I think there's a way to say, even within what you are proposing, to say, we're going to look at 2 MCF versus the 10 MCF, that's kind of the default. And to say, all right, here's our wells that are low producing, even under what we're considering low producing. And then some kind of explanation of, here's something that's less than 2. Here's why it's okay. Here's why it's not being moved to a plug-in and abandonment system. Here's why, we're assessing these wells for mechanical integrity issues. Here's why we're looking at the maybe not economic, but beneficial use of the well with respect to dewater. Some kind of explanation for that. And I think big picture, again, I fully understand that this is a unique situation. And, if we were looking at somebody in the DJ and them saying, well, I think we'll be able to reach it, it'd be a very different conversation. I understand that there are significant differences both in your field, both in the fact that it's coal bed methane, both that it's a much shallower compared to a lot of the wells we see, what we're looking at. But ultimately, what I'm trying to impress upon not just you, but other operators listening in as well, is saying we'll follow the rules is not really providing us information. And when the rules, again, say a demonstration of how the operator is planning for the retirement of its oil and gas operations based on the projected life of the field, age of the infrastructure, out of service, inactive, and low producing wells and related information, saying if it's not beneficial, we're going to plug it. That doesn't take into account those different variables that are discussed within the rule. It doesn't take into account what you're planning to do. And so I think, again, I'll kind of leave it for there right now, and I'll see if other commissioners have any comments or questions about this before we maybe get into some of the details on reclamation issues and things like that. But that's, I'll say, one of my biggest concerns right now is that just saying we'll plug consistent with the rules doesn't tell me anything about the age of your infrastructure as well. It doesn't talk about, there's no discussions, as you said, we'll take into account mechanical integrity issues. Well, it doesn't provide any of that information. I appreciate you pointing back to your compliance history and plugging when necessary and running the MITs, et cetera. But just a reliance, even within what you just said there as well, just a reliance on what you've done in the past as a company doesn't tell us how this is going to be eventually retired.
As I said, Commissioner, we're happy to continue to try and provide this information. I can tell you that this has been a topic of discussion amongst operators. I think many of us are struggling with this issue because we do have rules that we have to comply with. I think we have provided you with the age of our infrastructure. We provided detailed information on when the field was drilled, the interval of when the wells were drilled. This information is all provided, of course, in the ordinary course of business. We report to the state monthly what the production is from each and every well that we have. That's not to say that I'm suggesting we won't do these other things, but I think we have endeavored to provide that information. I don't have any wells. What's the criteria again? My wells are either shut in or temporarily abandoned. There's an inactive list. We don't have that set of circumstances to address. So I can certainly put that into an asset retirement plan now that I understand you're concerned about that, but many of them aren't applicable to us. I'm just reiterating, we're trying to be as responsive to the questions you're asking as we can. And we'll continue to go further. I have no issues putting in the additional information about mechanical integrity. Yeah, I think my previous position would have been it's redundant to what's in your rules, which we're complying with. But we can add that. We can add information about economically producible reserves. We can provide that to the ECMC staff. We provide a lot of that type of information as it is. We maintain a mechanical integrity list. I think so does the ECMC to assure compliance. So I think many of the things that you're concerned about, which I understand, are things that we're actually doing on a regular and ongoing basis. That's why I point, for instance, to our compliance history. There's no effort on our part to avoid the plugging and abandonment of wells, or there's no effort on our part to avoid being responsive to your questions. In some parts, we're seeking guidance on exactly how to do that.
All right. Further questions from commissioners? Commissioner Ackerman?
Thank you, Mr. Chair, and thank you to Evergreen for your continued work on your financial assurance plan. I appreciate the discussion so far. I continue to believe it's very important to get these right. To me, getting them right means that those companies who develop and operate the wells have a full plan to specifically provide for all costs of complete plugging, abandonment, reclamation, and remediation of all of its activities. And I hope you'll forgive me. I recognize that you significantly covered the point of demonstrated costs in our hearing last week, but I wanted to be crystal clear on what costs were demonstrated. So you mentioned a couple of times that ENR's costs have been lower than ECMC estimates, and I think specifically to the issue of reclamation. So I hope you understand my continued scrutiny of the subject of demonstrated costs. One of the primary issues during our August hearing on ENR's financial assurance plan, from my perspective, was that ENR's final site plugging, abandonment, and reclamation numbers were diminished because they always, or almost always, included predominantly in-house labor. And I think we're all aware that the financial assurance philosophy would set appropriate amounts that would be necessary for the state to hire a separate third-party contractor, as was recognized by you, Mr. Joy, in the last hearing, to complete all aspects of the reclamation for which you've submitted demonstrated costs, but also for plugging, abandonment, and remediation. So just a couple of questions. First, dialing down to the specific issue of reclamation, for which ENR has submitted demonstrated costs. ENR's demonstrated costs in Addendum 1 were for location and access reclamation projects for 11 wells that have been previously and permanently plugged and abandoned. In the previous hearing last fall, ENR discussed in pretty good detail the practice of Evergreen using in-house labor on these types of sites, and that being a primary reason for site closure totals being so low. And so, Mr. Joy, I think you mentioned that all demonstrated costs submitted in that addenda, in all of the addenda, specifically Addendum 1, were for third-party costs. In reviewing the figures for many of the wells in question, it seemed to me that a lot of the costs were largely for the purchase and delivery of materials. And, it was a bit tough to tell, but I did see some, but not many specific line items that seemed to be for on-site labor. So just to clarify, ENR is attesting that the figures included in the submitted demonstrated reclamation costs are all third-party figures. And they're also attesting that these are total costs for reclaiming these sites, but not for plugging and abandonment. And they're also attesting that no in-house work took place on the plugging, abandonment, reclaiming, and remediation of those wells. Is that all correct?
Largely, yes. So let me explain. When I say largely yes, I'm not intending to equivocate on what you said. I'm trying to provide additional, hopefully, clarification. Going back to last August, I think you did hear a substantial amount of information about plugging, abandonment, particularly reclamation costs. And my recollection, having reviewed that and having been part of it, was that was really intended to cover go forward costs and expenses. I think one of the things that the commissioners appropriately identified was last August, ENR's staff and personnel did not explain to the commission what its demonstrated costs to that point had been. So we went back into our accounting records, pulled out and provided the ECMC as part of Addendum 1, the actual costs associated with completing 11 complete reclamations that had been done by ENR during our period of ownership, predominantly in 2019 and early 2020, before we had taken the step of vertically integrating our construction services. So we didn't have those services in-house at that point in time. So what you are looking at are accounting records and invoices of all of the costs, including third-party labor, to do the plugging, to do the reclamation component of those locations. The plugging had been done by Pioneer in the 2018 period of time as we were taking over operations. And so even though it might have been done while ENR was the owner, the actual plugging piece would probably have been arranged by Pioneer before us. We're using the default $10,000. Those are demonstrated costs for the reclamation activities. And again, they were all done by third parties. The reason you would see something like an invoice for labor is because it was not our practice then, and has never been our practice, to essentially pre-package everything. So we don't give it to a contractor to say, submit me one invoice for services as provided, $2,251. We don't do that. We require the breakdown of the individual costs for each component part. We approve and pay those invoices directly. So if equipment was hauled to the location, we would have an invoice for that. It would have been arranged by the contractor, but we would pay it. There is labor charges to the reclamation. There would have been labor charges for Purgatory Valley Construction or Maya Construction or Doubletree Construction. Those are the three main contractors we would have used at that point. They would have provided us that invoice that we would have then paid, and we put those invoices into the record. So they are, in fact, the reclamation costs associated with a third party doing that work. And I think that's responsive to your question, Dave.
It is. Thank you, Mr. Joe. I appreciate that. I appreciate that additional information. A little bit of follow-up there. So there are some sites where I couldn't discern any labor costs at all, right? So for example, I'll just take the first one on the list, the first well on the list. I don't want to get into proprietary information. I'm not sure where that line is, so I'm careful with my words here. But the first one that I see on page 12 of Addendum 1 is solely for delivery of materials. I don't see any other charges and costs. So can you address that in sites like that where we only see what appears to be delivery of materials? How is the remainder of the reclamation costs covered in I think it's okay to just say this is the powerhouse well I'm talking about. And I'm just using that as an example. There are others.
I'd have to see the actual invoice that you're looking at and the accounting detail for the entire location, which of course I'm not looking at. If Mr. Lepore or Martin can somehow figure out how to provide that to me, so that I can see what you're looking at. Otherwise, I'm not sure how to answer the question. I can speculate, which is always dangerous, that you're just looking at an invoice for the delivery and not a separate invoice for the labor. But I don't have a better answer to that because, again, I'm not looking at it.
Thanks, Mr. Joy. That is possible, and maybe we can circle back to that one if somebody could come up with an answer to that, just to help me understand where those other costs are being accounted for. That said, on to the issue of demonstrated costs for plugging and abandonment activities. So I think the rub for staff in the director's recommendation was really specifically on this issue. So really the pertinent and necessary demonstrated costs we'd be looking for at this point would not be anymore for reclamation, which had been provided, as you noted, and accepted, albeit tentatively in the director's recommendation, but rather for plugging and abandonment. And so back in the August hearing, I asked a similar question, and the 11 projects that have been submitted have been for reclamation costs for wells that were previously plugged and abandoned, as I understand it. Do you have any specific information on the actual plugging and abandonment costs for those 11 wells, preferably adjusted for inflation, to demonstrate what those accurate costs would be today?
No, we do not. What we did for the revised plugging, abandonment, and reclamation plan that we've provided is we used the ECMC default of $10,000 for the plugging and abandonment portion of the cost, and then did the demonstrated costs that we actually have incurred for the reclamation component. I provided testimony, as you're aware, that our authorization for expenditure that we internally prepared to evaluate what our costs would be today for the plugging and abandonment piece are about $6,000. We prepared the entire plan assuming that $10,000, which is again the ECMC default, would be used for the plugging and abandonment piece. And so there's the plugging and abandonment component. Maybe Mr. Lepore can share his screen and pull that piece up for you. And then there is the single well financial assurance for the reclamation piece, which varies by reclamation complexity based on our demonstrated costs.
Thanks, Mr. Joy. And as I understand it, the $10,000 was for 259 specific wells, and then a $30,000 figure for 2 specific wells that are deeper wells.
Correct.
But that $10,000 wasn't extrapolated across the entirety of the 2,002 wells owned by ENR. Is that correct?
Correct. So our single well financial assurance proposal uses the $10,000 per well for the plugging and abandonment piece for the 259 low producing wells. It provides 30,000 for the 2 low producing wells that are at a depth below 4,000 feet. They're about 4,600 feet. And then it includes the demonstrated reclamation costs associated with those locations. So there are 261 wells and 217 locations, because in multiple instances, we have more than one well on location. And for the balance of wells that are not covered by single well financial assurance proposals, we proposed a blanket bond.
Understood. Thank you again for that clarification. So for all of those single financial well assurance wells that are just mentioned, the 261 wells, as per the director's recommendation, staff doesn't have an issue. It's specifically with the amount per well of the blanket bond for the remainder. And so again, I recognize staff tentatively doesn't have an issue with the single well financial assurance plan. So to me, the focus then becomes upon the amount per well in the blanket bond. And the amount that would be the appropriate amount there, that really is my focal point at this point. Besides the, reiterating the points made by my fellow commissioners on the asset retirement plan as well. And finally, just to be clear on remediation, again, thank you for addressing the open remediation project list and for providing addendum number 3. I found it to be helpful. I think you mentioned during the last hearing that you do employ 20 or so reclamation and remediation specialists in-house.
Yes.
Please correct me if I misheard that.
So you did not assure that we have 20 construction, remediation, reclamation professionals, and about 15, can vary by the day, of course, well services individuals who are people who actually run ENR owned and operated workover rigs, which is the equipment you'd use for plugging and abandonment. So in total, for PA and R, we have about 35 professionals and a full suite of equipment on staff.
Thank you, Mr. Joe. I appreciate you reiterating that point. It's important to understand for the capabilities that ENR has while it's in operations. It doesn't necessarily address the situation in which the financial assurance plan would kick in and ENR would not have the capabilities to take care of those wells, but it is important information. Thank you. On the remediation plan in addendum number 3, I really just have the same question. So no in-house work, even given the remediation specialists that you have on hand, no in-house work on remediation was used on any of those sites, or was in-house labor actually used, and then the demonstrated costs or estimates of what the third-party labor would be for the purposes of this hearing?
So two completely different sets of circumstances, Commissioner. For the demonstrated reclamation costs, which is the addendum 1, those are all third-party labor costs. And even though going forward, ENR would do that work itself, for purposes of financial assurance and computing the plan, consistent with past comments from yourself and in particular Commissioner McGowan, we use third-party costs because that assumes that ENR is not there. And so when it comes to the remediation, ENR clearly was there. That was all done by ENR staff. It was all done in-house. There were 21 remediations as of August 31st of last year. Staff wanted us to address. Thus far, 19 of those 21 have been addressed, and either a Form 27 has been approved or it has been submitted to ECMC for review and presumably approval. There are 2 remediations that remain open, and then, as I mentioned last week, they're weather-dependent construction activities. But that activity will be done by ENR's 20 or so, actually take 2, in-house remediation staff. And those costs are our actual costs.
Actual in-house costs.
In-house costs, yes.
Thank you, Mr. Joe. So just to be,
try and estimate third-party costs for that. We already did the work.
Understand. So just to be clear, in addendum number 3, there are costs, some of which are listed as reclamation cost, some soil sample costs. Those are all in-house costs.
Well, the soil sampling costs would be third-party lab costs.
Understood.
There would be third party. When I say third party, there'd be material costs that were listed there for mulch and for seeding, of course, that you have to do. So where there are third-party costs, we have provided that information.
Thanks, Mr. Joy. So I appreciate all of those clarifications. All of that discussion, Mr. Chair, so far, in my opinion, was within the confines of what staff has found acceptable, albeit, like I mentioned, tentatively. And so to the point of the blanket bond number, I would agree with Commissioner McGowan. And I'd like to pose a question to staff, Mr. Chair, to be answered at your timing convenience. But I think it would be important to hear someone from staff talk a bit about the orphan well program, specifically maybe remind us of the actual cost to plug, abandon, and reclaim wells under that program, and if possible, give us some high and low figures for those operations. I'd specifically be interested in the lowest actual costs that the orphan well program has encountered on the ground to plug, abandon, and reclaim any well. And that's all I've got for now. Thanks.
Great. Okay. Hopeful that staff is listening in and will be able to provide some additional perspective. Maybe we can try to finalize discussions for Mr. Joy and the attorneys on the panel at this point, and then we can move to staff. And then I think at the end, we would provide the attorneys and Mr. Joy kind of a final rebuttal position statement. Further questions? All right, seeing no further questions, Deputy Director Cuthbertson, are you with us, or Director Murphy? Hello, good to see you. Assume you've been monitoring the dialogue here and would love to provide staff with some perspective to speak to us.
I'll be happy to. I can sort of give you a summary of what I think I need to respond to based on the questions that have been asked. It might be helpful just to hear the overview of what we did put into the director's recommendation, which Mr. Joy's testimony, I think, fairly represented in his previous testimony for sure. And I'll just start ticking them off. Demonstrated costs. We don't have a sufficient project load in the orphan well program yet in the Raton Basin to provide any substantive comparisons to the information that Evergreen presented. When the director reviews an operator's asserted demonstrated costs, we look for several things. We look for, was the work actually done? Is it a reasonable estimate of the work to be done? Does it provide substantive documentation toward the costs? Is it comprehensive in its nature? Does it address all of the issues associated with a typical reclamation? And then we do reach out to see what our experience is in the setting. As you have heard before in testimony, plugging, abandonment, and reclamation costs vary significantly. I will tell you the lowest number that the orphan well program has experienced is $165 to close a site. Now that's obviously the extreme. That's an anomaly. But it was a site that was PA'd, reclaimed. There was just some final cleanup to do. So the costs vary wildly and widely. We have ongoing projects in the orphan well program that are not yet complete, that are over $1.5 million. So there is no red light, green light number from our experienced costs, from the costs that we've realized with our orphan well program, but occasionally do get a sense of, is the operator's proposed demonstrated costs, are they in the ballpark, right? Are they within reason? Are they not wildly different than what similar sites that our orphan well program has experienced? So that's the demonstrated costs. In regard to Evergreen's proposed demonstrated costs, like I said, we were concerned that maybe there was that they were lower than what they should be, But in order for us to go through that exercise would have required a several month detailed, our own detailed design and review, which we did not feel like was appropriate given the weight that that particular factor played in this plan. And instead, as has been observed, our director's recommendation noted that that's on our list of things to do in an annual review of this plan, is to continue to look for more robust confidence in the projected demonstrated cost values that are only being used for less than about 10% of their wells. And I think that's the important point that Commissioner Ackerman made from the director's recommendation, that we tried to make in the director's recommendation, is that while the demonstrated costs may not be completely perfect, they may still need some analysis. We're not sufficiently concerned with those at this point in time to suggest that the work required to vet those numbers was necessary to review this plan. The thing that the director was more concerned about is, the characterization of this plan. It is based on the option 2 characterization. An option 2 says that an operator can include up to 5% of their low producing wells as part of their blanket bonding, but that for low producing wells beyond that 5%, they have to provide single well financial assurance. And that's why you see the breakdown. Evergreen has followed that model in their proposal for their option 5 plan. At least that's my perception of what they've done. I haven't heard that from their mouth. And so that's why you see single well financial assurance only being addressed for the 261 wells, not for all the wells. And so the director's response to that model is, we agree. We can see the rationale of that model, because this operator, the impact of a low producing well on this operator does not have the same impact that it has on normal type operations. Meaning, if the number of low producing wells is some kind of an indicator that an operation is near end of life, we agree that that's not necessarily true for this particular operation. And so we're comfortable with the 10 MCF not being followed, and instead using a much lower number of 2 MCF. We understand that rationale and think that that's appropriate. What we don't think is appropriate is then to deviate and abandon the model and not require the blanket per well bonding for all the rest of the wells in accordance with the option 2 model. We haven't seen any. I appreciate the testimony was that it was some percentage, that the blanket amount in the rules was some percentage of the single well financial assurance, and that percentage was the commission's intent. We did not see that in the rules. The director does not see that in the rules. We did not find that in the contemplation of the rules during deliberations. We believed that blanket bond was instead a reasonable bond for wells that qualified as an option 2, and that it wasn't some percentage of the single well financial assurance that could be required. And so that was the foundation for our director's recommendation, is that we found all of the aspects of the proposed plan to be reasonable, except for that one piece. And that was the reason that we ended up recommending a denial of the plan. And we did have conversations with Evergreen on a couple of occasions, at least, in the process of going through that review. So those would be my summary comments. I'm happy to answer any specific questions.
Fellow commissioners, specific questions for Deputy Director Cuthbertson. Well, you did Commissioner Ackerman.
Yeah, I'll have one, and maybe it's self-evident, Deputy Director Cuthbertson, but I think my question to you would be, what would be helpful for ENR to demonstrate with regard to the blanket bond coverage, should they want to continue to pursue a number lower than that default number?
Thank you for that question. I don't know. I don't think that there is, working from the foundation that the blanket bond number was a reasonable number the commission determined for the category of operations quantified as option 2. I think that's I think that was set by deliberative, thoughtful consideration, but it's a number that was set. I don't recall the rules providing any foundation for it beyond reasonability. And so I have no basis upon which to deviate from that number, as I agree that it's, it's a reasonable number to think about. A blanket bond to plug, abandon, and reclaim of $10,000 per well is reasonable. And so I can't contemplate what information would be helpful to convince me that that's not an appropriate number.
Thank you, Deputy Director. That's my understanding as well.
Other questions for Mr. Cuthbertson? Thank you very much, Deputy Director Cuthbertson. We appreciate that point. I had asked earlier if there were further questions for the panel. I didn't see any one last time. All right, seeing no further questions, I think it might be appropriate to take a 10-minute break, and then when we get back, we will hear from the panel with regard to kind of concluding statements, if that's fair. Let's return at 10:28.
Mr. Chair,
Yeah, Mr. Lepore.
would you give us 15 minutes?
Yeah, absolutely. Okay.
Thank you.
10:35. That's
Thank
like 17 minutes. But I'm bad with math. All right, we are back on the record in docket 221100286. We took a break, and I believe we now have an opportunity to hear from the applicant in kind of a closing statement sort of perspective, if the applicant is ready.
We are, Mr. Chairman, if you'll give me just about 10 more seconds.
9, 8, 7.
You're very gracious, sir. Thank you. Thank you for the opportunity, Mr. Chairman. I appreciate it. I do want to make some comments and hopefully clarifications. I also want to say that we might want to ask Mr. Cuthbert some questions here in a little bit. So I want to start here. This is not an option 2 financial assurance application. It is an option 5. It is an option 5 for a reason. The reason is that the option 2 amounts of financial assurance are unnecessary and unreasonable for this operator, for this operator's economics, for this operator's demonstrated costs, and for every other aspect of financial assurance. For this operator's orphan well risk, option 2 does not make sense, is not reasonable or necessary. In putting together the plan, we did use different elements of the financial assurance structure that the commission created through a very lengthy financial assurance rulemaking that both Mr. Martin and I participated in, about as completely and fully as you can. Because it's not an option 2 plan, we don't understand staff's seeming adherence to the blanket bond amount under option 2. As we tried to point out in our financial assurance plan, a $10,000 blanket bond is about 50% of this operator's demonstrated plugging, abandonment, and reclamation costs. That is a huge number, a huge percentage. We also believe that there is a relationship between the option 2 blanket bond amount of $10,000 for an operator with the number of wells that Evergreen has. There is a relationship between that $10,000 amount and the $110,000 presumed costs. I don't understand how there isn't a relationship there. The relationship is 9%. $10,000 is 9% of $110,000. Mr. Messner, I can see you shaking your head, and you can disagree with me, and you can tell me about it later. If you just made that number up, that's fine. But in our view, there's a 10%, 9% relationship there. We use that to come up with the $2,600, which is a 13% relationship to our demonstrated costs of $21,000. So it's higher as a percentage basis of our demonstrated costs than the $10,000 is for an option 2 operator. If we have to use option 2 blanket bond, what is the point of option 5? You have completely negated the purpose for which I think option 5 was created. To have an operator demonstrate to you their economics, their costs, their orphan well risk. If we go back to option 2, I just don't understand. I don't understand the point. I don't understand why you created option 5. So Mr. Cuthbertson said that from his viewpoint, there was no relationship to the $110,000. And I guess the question I have is, how did you come up with $10,000 then?
Mr. Lepore, is that a question for Mr. Cuthbertson?
I think that we should ask him that question.
Mr. Cuthbertson, are you still with us? Hi.
Good afternoon or good morning. Just feels
And-
like afternoon.
Knowing that the whole protocol was created by the commission, I don't want to put you on the spot if you don't really have an answer to the question. But if you had some thoughts, we'd love to hear them.
And I don't mean to be flippant in any way, but I didn't come up with that number. That is not the director's number. That is the number that the commission deliberated on and found to be reasonable in the process of their rulemaking. And I have no basis upon which to compare it other than that.
So, Mr. Cuthbertson, in your estimation, there's simply no relationship between $10,000 and the presumed blanket, the presumed plugging and abandonment costs of $110,000. Is that correct?
No, that's not correct. You're right. There's a mathematical relationship. What I'm saying is I don't see anything in the rules or the deliberation associated with the rules that established that the reason for the $10,000 number is because it was 9% of another number. I don't find any basis for that.
Thank you. And do you have any insights into how the commission came up with the $10,000 number?
I do not personally.
All right.
All right. And just to create the procedural record that is infallible, Mr. Cuthbertson, would you please raise your right hand and swear that all the things you've talked about have been truthful?
My name is Scott Cuthbertson, and I swear that I have told the truth and will continue to do so.
Thank you so much. All right. Anything further in closing, Mr. Lepore?
Yes, sir. Thank you. One last thing. Two last things. At the close of the August hearing, the commission clearly articulated 3 issues that they would have asked Evergreen to address. The amount of the proposed blanket bond was not one of those things. So Evergreen did a lot of effort, a lot of work, a lot of time into responding to those 3 issues. Now staff raises the blanket bond amount, and there's a new issue for us to grapple with. The asset retirement plan was raised before. We tried to answer that. We're happy to continue to try to meet this commission's expectations on what that is. Last point is there is precedent for varying from the blanket bond amount set out in the formulaic options 1 through 4 for an option 5 operator. And that precedent is own resources. Some of you have expressed dismay that we are referencing own resources. I will say again, it's the one example that we have. They are a similarly situated operator. And I'm very aware of what their financial plan was based on. So when we went to staff with own resources plan, staff objected on the grounds of the difference in the low producing well numbers and the blanket bond amount. The blanket bond amount of OWN's approved plan is $700 per well, which is equal to 5% of their demonstrated costs. Again, the offer on the table from Evergreen is 13% of their demonstrated costs. So maybe I'm too focused on this demonstrated cost and percentages, but I don't know a better way to sort of encapsulate the financial assurance as it relates to an operator's orphan well risk and financial health. In a perfect financial assurance world, an operator with 0 risk would pay 0 financial assurance. And an operator with 100% risk would pay 100% of the costs. Evergreen is somewhere in between. Evergreen is not a 50% risk to abandon all of its wells before plugging and abandoning them. Is it at the same level as an option 1 operator? We have not said so. We've said it's a little higher than an option 2 operator at 13%. Last thing I'll say is this, and maybe this should come from Mr. Joy, but I have his blessing to say this. Evergreen cannot secure a $25 million bond. Flat out, straight up, pure and simple. The economics of a $25 million bond aren't there for this operator. So if that's where this lands, there's a much, much different conversation that has to happen. I appreciate your time, commissioners.
Yeah. All right. Thank you very much. Mr. Cuthbertson, see you raise your hand.
Yes, and I'm sorry to interject, Chair. I just want to comment or respond to one of Mr. Lepore's first comment in this last session, where he, my understanding was that he asserted that the issue of the blanket bond was just now being raised. And I just want to bring to the commission's attention that the director raised it in the first director's recommendation in the August hearing as well. We have not changed our position in regard to the efficacy and equity of that being a reasonable bond per well. The only other thing I would say is that the director agrees that this is an appropriate option 5 plan because it is not a typical operation. And the reason that we support the option 5 plan is for the consideration of the reduction of the low producing threshold from 10 MCF to 2 MCF. We believe that is the foundation of this operation's qualification as an option 5 plan. And so I just wanted to provide those comments of clarification.
All right. Thank you very much. In an effort to make sure that the applicant is heard last, anything further following those statements, Mr. Lepore?
I think what I said is that the commission's comments and the 3 specific things the commission asked us to look at did not include the blanket bond amount. I don't recall whether the director's recommendation cited the blanket bond amount. And I will lastly add that since the August hearing, as we covered last week, Evergreen has raised its overall financial assurance by about 40% compared to, on a per well basis, we went from about $3,300 to about $4,200 per well for all of its wells. So there's been a substantial increase in the total financial assurance that would be provided.
All right, thank you for those comments. Commissioners, before we move to deliberations, one last opportunity for questions. Commissioner McGowan?
Thank you, Mr. Chair. And thank you, Mr. Lepore, for those thoughts. So if we're going to bring up own resources, another component that OWN has that I am struggling with here is their asset retirement plan. And I don't want to bring up, they have committed, I have this runway, I'm going to set aside a certain amount. If I don't plug and abandon a certain amount, I keep adding to that retirement plan for my wells. My wells are like little people. By the time they get to the end, I want a retirement plan for them. I want to know that there's something that can address their final retirement. They can offset P&A costs from that amount that they set aside. And so while the blanket bond might be a lower amount, they have also committed to offsetting risk by a long-term retirement plan. So there's a slight differentiation to what you all are proposing and what we considered when we were talking to OWN about their financial assurance plan. So I just want to make clear that in my mind, they're doing an additional step with their asset retirement plan to offset risk and a commitment to P&A when wells get to a certain point that they can use that amount that they're setting aside to P&A wells. So I do think there's an additional component here that was part of the consideration.
Thank you, Commissioner. I appreciate that. And we discussed a little bit last time. I think Evergreen would be fine with a financial assurance plan that included a component of money into a trust account. Like OWN's, it would most likely include a surety bond as a portion and an annual contribution as another portion. When we presented that to staff, and maybe we did not present it as well as we needed to, they shut us down. They said, and we referred to it as a trust account, and they said they were not prepared to do that, and that it would take them months to get to be there to do that. I think I can say on behalf of my client that we would be happy to work on that combination of financial assurance and a surety bond and an annual contribution. And maybe there can be a little work group around that to some extent. So if that's, I'll stop there. I think that is a workable solution. And I see my client raise his hand, so.
Mr. Joy?
Thank you, Mr. Chairman. And again, thank you, Commissioner McGowan, for bringing up the issue again. I don't want to sound critical of staff. That's not my intent. Mr. Lepore accurately stated this. Evergreen actually approached staff about the plugging and abandonment and trust concept. We're supportive of that. I've spoken with OWN Resources CEO. We've actually committed to aiding and assisting and working with him already on an informal basis and are doing so. When we approached staff with that, what they essentially said is that there's a transition and amongst the financial assurance professionals, and that they didn't have the resources right now to do it. So we took that to them. That, from my perspective, Commissioner McGowan, would actually be preferable. Without going into too much of the detail, if I could take the bond premium and put that into a plugging abandonment and trust account, and that's what you would do is if you do P&A, you subtract that amount. If you don't, you put the amount into the trust and it grows with interest over time. That's a true retirement account. For an operator like us that has a field with a life of 30, 35 years, that's a wonderful solution. And it's something I happily would commit to doing. Right now, I'm at a financial assurance hearing where ECMC staff has said, at least at this point, they don't have those resources. And when I read the 700 series rules, the first thing it says is our preferred method or the approved method is a cash bond or a surety bond. And so Evergreen is here trying to comply with the rules as they're written, with the requests of the commissioners, with the physical limitations and demands of staff. Mr. LaPour's correct. We would do that. I think it's a great solution. It just doesn't seem to be available right now. And so if what you'd like to hear from us is that we would put the surety bond that we've proposed in place now and work with the other operator or other operators, there may be more than one, I guess, looking at pursuing a PA and our trust, absolutely we would commit to doing that today. Would we commit to some hybrid mechanism as Owen has done where we put up the bond today and or in 30 days or 90 days, I guess it is, and replace that with the PA and our trust when it's available? We would do that as well. It just doesn't seem to be an instrument that we have today, so we didn't put it before the commission because the staff, again, I'm not criticizing, they just said, we don't have that mechanism in place yet.
Mr. Chair,
Allen?
thank you. Could I ask Mr. Cuthbertson to address this? Because I think the commission gets to decide what we were going to do, and the trust is allowed in the rules, and I realize that we're working on it, but I would like Mr. Cuthbertson to maybe address this.
Mr. Cuthbertson?
I don't have the same recollection. My recollection of any conversation that we've had regarding trust fund, I think, is closer to what Mr. Joy has represented. We may well have said that would be more difficult for us to do, but I would say that I don't have the authority to not allow an operator to pursue a trust fund solution. That's contemplated by the rules, and just because it's more difficult for us to do than a surety bond, that would not be anything that I would rely upon in terms of an analysis of an application. So I'm not sure where the really strong opinion that staff shut down this operator in their pursuit of a trust fund, but it's not my recollection of any conversation that we've had.
Thank you, Mr. Cuthbertson and Deputy Director Cuthbertson. That's all I have for now, Mr. Chair.
All right. Seeing no further questions, I believe at this point we would turn to deliberations amongst the commissioners. Commissioner Messner?
Thank you, Mr. Chair. Appreciate the conversations that have been had here and the conversations that occurred on March 27th when I wasn't present. It was good to listen to the hearing and the information that was provided both by the operator as well as the questions that were asked by commissioners. I think that a lot of work has been done on this. I want to start my initial thoughts here with just providing some information from the rules as well as from the statement of basis and purpose that I'm basing some of my thoughts on. So initially, as I reviewed the rules and I reviewed the statement of basis and purpose and applied this operator's proposed financial assurance plan to that, I did look at the 100 series rules and the definition of low producing wells, which means an oil or gas well that produces a daily average of less than 2 barrels of oil equivalent or 10,000 cubic feet of natural gas equivalent of gas over the previous 12 months. In the statement of basis and purpose on page 16, the commission determined that wells with an average daily production of 2 BBL per day or 10 MCF per day of gas over the previous 12 months was a reasonable threshold for identifying low producing wells. These thresholds reflect a level where the well is still producing in sufficient quantities to potentially be profitable, but may be at the point in the decline curve where it will become inactive at some point in the relatively near future. This allows the commission to revisit a well status prior to it becoming inactive. I also looked at the 100 series definition of single well financial assurance. Single well financial assurance means either A, the sum of an operator's demonstrated costs of plugging and abandonment of the well and the associated and apportioned reclamation cost for the well, which is calculated by dividing the demonstrated reclamation cost by the number of wells on the oil and gas location or at the oil and gas facility. Or B, the sum of the single well plugging and abandonment costs and the single well location reclamation costs. In the statement of basis and purpose on page 20, it indicates where operators use demonstrated costs of plugging, abandonment, and reclamation. The commission intends for operators to include all relevant costs and information for their single well financial assurance proposal. I highlight information in their single well financial assurance proposal, including but not limited to known remediation issues, areas of initial and total disturbance for the oil and gas location and any associated offsite facilities, number of wells at the oil and gas location, whether the oil location has cut and fill slopes, and if slow, the slope ratio of both the cut slope and the fill slope, whether the oil and gas location has sandy soils, whether any salt kills have occurred at the oil and gas location, whether the oil and gas location is in high priority habitat, and whether topsoil has been salvaged at the oil and gas location. The commission also expects operators will support their demonstrated costs with, for example, 3 years of invoices from past plugging, abandonment, and reclamation operations, where possible, or a third-party estimate of plugging, abandonment, and reclamation costs. Based on a review of the evidence in the administrative record, the commission determined that these factors are most likely to drive remediation and reclamation costs. The commission recognizes that reclamation costs are primarily determined at the location level and not the well level. By taking these factors into account, the commission will be able to more appropriately tailor the amount of financial assurance required for each well. In the statement of basis and purpose on page 50, Rule 702 establishes the financial assurance requirements for plugging, abandonment, and reclamation of oil and gas wells, oil and gas locations, and associated oil and gas facilities. The purpose of the rule, like prior Rule 706, is to protect public health, safety, welfare, the environment, and wildlife resources, as well as air, water, soil, and biological resources, by ensuring that operators have the financial capability to fulfill all of their obligations under the Act and the Commission rules. Specifically, Rule 702 is intended to ensure that operators are capable of fulfilling their obligation to plug and abandon wells pursuant to the Commission's 400 series rules, to fully reclaim oil and gas locations pursuant to the Commission's 1000 series rules, and to properly clean up and abandon oil and gas facilities such as tanks and flow lines pursuant to the Commission's 600 and 1100 series rules. In the statement of basis and purpose on page 59 per Rule 702C, the Commission elected to use a daily per well production level as the criteria, given that production equates to the volume of the commodity that could be sold, and when considered across the operator's entire portfolio, allows some insight into the operator's overall financial health. Generally, the commission determined that operators with the higher average daily well production are at a lower risk of orphaning wells and are therefore required to provide a lower amount of financial assurance. This inverse relationship between production and risk cascades through the different options. The commission recognizes that a variety of circumstances may influence the appropriate amount of financial assurance. Accordingly, Rule 702C5 provides that where circumstances prevent an operator from meeting the requirements of 702D1 through 4, or other exceptional or unreasonable or unnecessary circumstances, an operator may file a financial assurance application that meets the rule of 702D5, or option 5. In creating option 5, the commission stressed that it was not intended to be a process whereby an operator may attempt to use option 5 for the sole reason of paying less financial assurance than provided for in other options. The commission intended option 5 to be available only in these circumstances, and the commission left itself with broad discretion to consider a variety of factors when presented with an option 5 financial assurance application. On page 63 of the statement of basis and purpose regarding Rule 702D5, the information requirements for option 5 plans are the same as all other options with some exceptions. Unlike the other options, option 5 allows operators to submit a unique financial assurance plan, though that plan must address all wells, including low producing wells, out of service wells, transferred wells, and other facilities as is required with financial assurance plans under other options. The commission, and I'm highlighting this, the commission intends that the operator will meet the single well financial assurance obligations of its low producing wells based on the production threshold and all allowances of the standard option structure. This is an important point. The commission also intends for an operator seeking an option 5 plan to provide support and justification for such request. Page 64 of the statement of basis of purpose, which talks about the director's review. The director's review also includes a substantive component as to whether the operator's financial assurance plan demonstrates that the operator will provide adequate financial assurance to comply with all of its obligations under the Act and the commission rules. The commission intends for staff to use their substantial expertise in financial assurance, plugging and abandonment costs, remediation, reclamation, and familiarity with the operator's overall operations compliance to exercise appropriate judgment and discretion when making a recommendation. So overall, option 5 was created to develop an opportunity for an operator to propose a unique financial assurance option where circumstances prevent an operator from meeting the requirements of 702D1 through 4 or other exceptional or unnecessary unreasonable circumstances. As stated in the SBP, in creating option 5, the commission stressed that it was not intended to be a process whereby an operator may attempt to use option 5 for the sole reason of paying less financial assurance than provided for in other options. As indicated by the operator, the financial assurance rulemaking directed that the commission shall require every operator to provide assurance that it is financially capable of fulfilling every obligation imposed by this Article 60 as specified in the rules adopted. The rules adopted a developed framework in which this obligation could be met with definitions, tools, and categories based on production levels through over a year of stakeholder and rulemaking work. The rules in this commissioner's opinion were developed to ensure that the operators were able to retire their own assets at the end of productive life. It was determined that through the rulemaking that the best indication of how close assets were to retirement would be determined by production levels. Understanding this, a system was developed based on production levels to ensure financial assurance mechanisms were in place as wells became less productive, including requiring single well financial assurance for wells at the lowest end of production. Evergreen Resources Option 5 plan consists of redefining low producing wells for their application from 10 MCF per day to 2 MCF per day, and have proposed a modified blanket bond for their assets above the 2 MCFE threshold. I would classify this as a modified option 2 plan. The standard option 2 plans were determined to be appropriate for operators with the level of production and number of wells that Evergreen Resources has in their portfolio. The standard option 2 level for which Evergreen Resources qualifies includes the benefit of utilizing a blanket bond in the amount of $10,000 per well for all wells not designated low producing, and also allows for up to 5% of wells designated as low producing to also be included in the $10,000 per well blanket bonding amount. All wells considered low producing beyond this 5% allowance would be required to be assured at single well financial assurance amounts. This is where demonstrated costs may be applied in lieu of the default amounts contemplated by the definition of single well financial assurance. And Evergreen Resources, in my opinion, has adequately showed a demonstrated cost of approximately $20,748 per well including reclamation. As I indicated previously, Evergreen Resources has chosen to submit an option 5 plan, which is only allowed if the operator can make a showing that according to Rule 702C5 provides that circumstances prevent an operator from meeting the requirements of 702D1 through 4 or other exceptional or unreasonable or unnecessary circumstances. They have chosen to argue that demonstrated costs be applied to not only the single well financial assurance, but to the blanket bonding amounts as well, and have chosen to redefine the definition of low producing well from 10 MCFE per day to 2 MCFE per day to lower their single well financial assurance obligations for low producing wells. So my deliberative findings are as follows. Number 1, I do not believe the burden has been met to show compliance with Rule 702C5, which states an operator may only submit a financial assurance plan that meets the criteria of Rule 702D5 due to circumstances that make it unnecessary and unreasonable for the operator to submit the financial assurance amounts specified in Rule 702D1 through 4 or other exceptional circumstances. The circumstances for this operator seem perfectly tailored to the requirements associated with an option 2 operator as debated and determined reasonable and necessary throughout the financial assurance rulemaking. There is no indication provided that the operator would not be able to provide the necessary financial assurance associated with option 2, which at $10,000 per well is significantly lower than the operator's provided demonstrated costs. In addition, the operator has provided adequate information to allow for demonstrated costs to be utilized in applying single well financial assurance for low producing wells as required by option 2, which provides an additional benefit to this operator. As per the 100 series rule definitions of low producing wells and single well financial assurance, demonstrated costs are to be applied only to single well financial assurance obligations, not blanket bonding obligations. I will also quote the statement of basis and purpose, page 59, which indicates that the commission determined that operators with higher average daily well productions are at a lower risk of orphaning their wells and are therefore required to provide a lower amount of financial assurance. This inverse relationship between production and risk cascades through the different options. This is why this operator qualifies for option 2. In addition, it is important to note that again, in the SBP page 59, it states that by creating option 5, the commission stressed that it was not intended to be a process whereby an operator may attempt to use option 5 for the sole reason of paying less financial assurance than is provided for in other options. Number 2, redefining low producing wells, even in option 5 context, was something that the commission determined would not be appropriate during the financial assurance rulemaking. In the SBP page 63, it indicates, as per option 5 plans, the commission intends that the operator will meet the single well financial assurance obligations of its low producing wells based on the production threshold and all allowances of the standard option structure. It is this commissioner's opinion that allowing for a redefinition of low producing wells goes against the intent of the rules and the act. Again, I will reiterate that the rules allow for the use of demonstrated costs in applying single well financial assurance for low producing wells, but does not allow for a redefining of the definition of low producing well. Number 3, as to asset retirements plans, there was a lot of debate and conversation on this particular topic. It seems to me that the expectations associated with asset retirement plans are pretty standard business practice and is a pretty straightforward expectation that seems to be lost on this operator. Understanding the financial obligations of the operator to set aside funds or to show a plan on how the funds would be utilized in retiring assets over the lifetime of a well operation is what is expected in the asset retirement plans. And I saw no information provided in the asset retirement plan that shows a mechanism of how money would be set aside or how money would be budgeted within their operations to ensure that this operator would have the ability to properly retire its assets as necessary. And number 4, finally, I believe the director in her revised director's recommendation applied the rules appropriately in recommending denial of this application. As per the SBP page 64 regarding the director's review, the commission intends for staff to use their substantial expertise in financial assurance, plugging in abandonment costs, remediation, reclamation, and familiarity with the operator's overall operations compliance to exercise appropriate judgment and discretion when making a recommendation. Staff acknowledges that the operator is provided adequate demonstrated costs that could be applied to low producing wells within the option 2 structure, but that the operator has not met the burden to show that the circumstances prevent an operator from meeting the requirements of 702D1 through 4, or that there were other exceptional, unreasonable, or unnecessary circumstances. So therefore, it is most appropriate for this operator to be classified as an option 2 operator with demonstrated costs allowed to be applied to single well financial assurance for low producing wells beyond the 5% allowance. Staff did indicate that they agree with the redefining of low producing wells, which I certainly want to contemplate as possible, but in my reading and understanding of the rules that were promulgated and the information that is provided in the statement of basis of purpose, I do not believe that this is allowed by the rules and the act. So I disagree with staff only on this point. So for these reasons, I recommend that we deny this operator's option 5 plan and approve an option 2 plan with single well financial assurance for all low producing wells beyond the 5% allowance, using the operator's demonstrated cost for single well financial assurance. Though I don't believe it's relevant, but since comparisons were brought up, I will note that this opinion that I'm sharing today is consistent with my opinion on the Own Resources Financial Assurance Plan. Thank you, Mr. Chair. Those are my thoughts.
Others with deliberative thoughts? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Commissioner Mesner, for, I think it's always good for us to remind ourselves, and the statement of basis of purpose is a good place for us to understand what we were contemplating at a certain point in time. And I think both sides have brought up some important points that are in the statement of basis of purpose as well as in our rules. And similar to last time we contemplated an option 5, I guess I think it offers an opportunity for some more flexibility and a different way to look at how to provide financial assurance for an operator. And I don't necessarily think that, I think that an option 5 could be appropriate for this operator. I think that there are some key pieces missing that have been brought up by staff and by commissioners. And the biggest piece missing for me still is an asset retirement plan, which to me right now feels like I'm going to follow the rules and plug wells when they need to get plugged, which is not an asset retirement plan. It feels inadequate to me, and it does not give me assurance that the operator is thinking long-term about making sure that all these assets will be covered, which I think is required by our rules. And so I don't know if I'm hesitating to say, like, let's continue this again and take another bite at the apple. If we deny, I don't necessarily think that the $25 million is appropriate either. So, which I think would be this, under staff's recommendation, would be the final amount. I'm not sure that the risk balanced with what's happening with the operator and its good standing. And I think that we all agreed at the August meeting, we didn't need to hear more about their business financials. So I find myself kind of circling the airport and not figuring out how to land, quite honestly. And so I would look forward to hearing from my other commissioners, but I appreciate Commissioner Mesner's viewpoint, and I think it's very consistent with last time we discussed an option 5.
Commissioner Ackerman?
Thank you, Mr. Chair. I wanted to note that I appreciate the good and strong work by Evergreen Natural Resources. I want to note that Evergreen's an operator in good standing. They're doing good work. They're making the most of the assets in their control. And as has been previously noted to us by local officials, the company has significant support in and amongst the community in which it operates. this significant local support for this operator says a lot to me about it, and I don't intend in any way for my comments today to be an indictment of the character or work or operations of Evergreen. I particularly appreciate Mr. Joy's professional and analytical approach to this issue. I would agree that I don't have any issues with the financial stability of Evergreen or their ability to currently meet their obligations, so long as the company is operating. And again, I would remind us of the obvious that financial assurance is specifically intended to meet these obligations in the event that an operator is defunct or otherwise unable to meet its complete or partial plugging, abandonment, reclamation, remediation obligations. I appreciate the submitted materials. The application details reclamation costs, as I've noted, for 11 wells of varying complexity, but it does not detail other significant costs for the other aspects of actual site closure, that be plugging, abandonment, somewhat unclear on total remediation. Rather, the default amount of $10,000 is utilized for those wells on plugging and abandonment, which makes sense to me. While staff argues that the submitted reclamation costs may be low, staff concedes that it understands the rationale and that there are ongoing opportunities to assess and adjust that figure over time if needed. Therefore, staff doesn't have any significant issues with the assessment and approval of reclamation costs associated with the demonstrated costs submitted by ENR. And I concur with staff's opinion that I think some of these costs could be low, especially given the varied terrain and topography in which ENR operates. Nonetheless, I concur with staff that demonstrated costs taken at face value place these estimates within the realm of reasonability, and I agree that there are ongoing opportunities to evaluate and address this point. Conversely, staff feels that the blanket bond from low-producing wells, as I noted during my questions, is significantly lower than what their experience dictates for the closure of these types of wells. And I agree. On the issue of demonstrated costs specific to this point, there are no specific detailed costs for plugging and abandoning wells that would support any kind of a demonstrated cost deviation from the standard blanket bond amount if an option 5 plan were to be adopted. Further, as noted a number of times today, there's no material asset retirement plan on which to base or estimate costs on those activities that will be absorbed by the company while it is in active operation. Although I appreciate the further elucidation of this point during the hearing today, I concur, Chair, with you that it didn't really translate to me into any specific asset retirement plan that's actionable. This, to me, is of particular concern, as in my opinion, it really leaves us no choice but to financially account for P&A of all of the operator's wells, further bolstering the argument for application of the standard per well blanket bond amount. I would agree with council that the purpose of option 5 is to demonstrate actual costs. And that would, actual costs that would demonstrate a reasonable argument to deviate from the standard amount set forth in regulation. And I agree with that. In adopting different potential options, especially option 5, really the commission by necessity introduced a less formulaic approach that introduced a demonstrated cost approach that relied heavily upon the demonstration of actual costs and includes some degree of subjective analysis to whether or not that approach can apply to a specific operator. And in my opinion, that really makes the option 5 plan a more rigorous demonstration in nature of actual costs than any formulaic approach or demonstration of partial costs that are contemplated in the more standard plans. So from my perspective, employing this option really requires a significant burden for the operator to demonstrate in all aspects that it's asking for a reduction from the standard specific demonstrated costs. Staff's opinion and testimony was that the operator was able to do so with regard to what constitutes a low producing well, although I note and agree with the thorough comments by Commissioner Messner on this point. In my opinion, the pertinent demonstrated costs in question for reclamation projects, remediation projects, and the single well financial assurance for 261 low producing wells was appropriately met if you accept the adjustment of the low producing well definition. Justification for reduction of a standard amount for the operator's remaining 1,761 non-low producing wells, to me, wasn't addressed or demonstrated at all in this application. Those demonstrated costs would have to include an acceptable sample of actual demonstrated costs specific to the complete closure, plugging, abandonment, reclamation, and remediation for those wells. As noted by Commissioner Messner, the intent there is to deviate from a standard specifically if an operator can justify that, hey, these are my actual costs, to deviate from that standard, rather than to make an argument that it should pay lower formulaically. To me, the demonstrated costs provided in this application were really only pertinent to reclamation of a redefined low producing wells, and to a lesser extent, remediation. And, you know, I've steered clear of the own resources discussion, but I did want to point out, to my point that I'm making here today, to the own resources plan, and I would point out not precedent, as was specifically noted during that hearing, but to their plan that was pointed to today. That plan included significant demonstrated costs associated with all aspects of closing sites, including complete plugging, abandonment, remediation, reclamation, as well as a detailed asset retirement plan, as noted by Commissioner McGowan. And it's clear that this application does not meet that standard, if that were a standard that were some kind of a precedent, which again, I would argue that it's not, and each of these plans is assessed in its entirety independently, particularly with regard to option 5. So I agree with the points that have been made that this operator does have quite a unique business model. It requires a degree of discussion, subjectivity, and flexibility, I think, on all parts. I do think that there is a way that we can get to a point where the commission feels comfortable. I personally don't feel comfortable with cherry picking a redefining of the low producing well, and then basing all costs on that. Now, to be clear, I do agree that I believe this operator's low producing wells in whole are likely, and this is subjective on my part, are likely less likely to be imminently closed than the classic low producing wells that we generally contemplate. So I think there are a few options from my perspective, and one of those options is to, as noted by Commissioner Messner, classify as an option 2 plan with the ability to demonstrate low producing well cost specific numbers. I think there is an avenue, as noted by Commissioner McGowan, to continue to discuss what an option 5 plan might look like. And I think that would require significant demonstration of costs or analogs and discussion with staff to reach a number that really would represent the most appropriate number for actual financial assurance for this company. So those are my thoughts. That's where I sit at this point, Mr. Chair.
Thank you for those thoughts. Commissioner Cross?
Thank you, Mr. Chair. And thank you to my fellow commissioners for going first. I'll start off by saying I do think that an option 5 plan is appropriate for Evergreen. I will start by saying I think it's important for operators listening in on this as well to understand that, at least in my opinion, an option 5 plan is available and intended for a very small subset of operators. I know that a lot of operators have submitted option 5 plans thinking that, well, we have unique operations and therefore we should be able to do something completely different. And I really don't think that that's what option 5 is intended for. When you look at our rules and what is intended by an option 5, it's not a matter of the operator not being able to pay into one of the other options, not being able to fulfill the requirements of the other options, but it's unnecessary or unreasonable to follow those options because of their unique circumstances. And here, one of the things that I think is important from what we heard last fall, what we've continued to hear, and what other commissioners are agreeing with, is that it's not an economic situation that makes it impossible for for Evergreen Natural Resources, similar to what we had with Own Resources, to say we can't follow an option 2, we can't follow an option 3, etc. It's based on the unique circumstances of the way our operations work. It's unnecessary or unreasonable for us to follow those options. And I think that, like Own Resources, I think Evergreen Natural Resources is in a similar circumstance. That said, I still think we do need to make sure that the requirements are being met. And I think that the defining aspects of what is low producing is a bit of a misnomer. I think it's a way of putting into terminology how the plan is being set to this individual operator's unique circumstances. I think big picture, my biggest concern, as is probably abundantly clear from my questioning, is still with respect to the asset retirement plan. Again, I know last week some of the questions focused on, well, we can't really provide a schedule because we don't know what the schedule is going to be. And I don't think an asset retirement plan needs to be, this is how many we're going to plug and abandon this year, this is how many we're going to plug and abandon next year. I think an asset retirement plan, as has been discussed, indicates here are the triggers. Here's what this operator is going to look at. Here's the decision-making points that say, okay, yes, this is not an economically beneficial well at this point in time, but for circumstances of Evergreen, what we're facing now, but this is still operationally beneficial. I'd start off saying, I think one of the important things is, I don't think it's appropriate for this to be looked at every 3 years in the circumstance. I think this is something that, according to the operator's own words, this can be looked at annually as well. And I think it's important to say, under what the operator is trying to do with their designed plan, here's what we think is perfectly beneficial economically. We're going to set those aside. When it comes to those that they're proposing the single well financial assurance for, here's what wells fit under that category. Here is why they are not part of a plug and abandonment plan. Here is why they're not part of the retirement plan. I think it's also appropriate, as discussed, there are certain wells that are being looked at for MITs. I think it's important to discuss why it's appropriate for an MIT, why it's appropriate for plugging and abandoning, why it's appropriate for restimulation. Having some more detail provided in that. I think critically where my biggest hesitation is, and I'll kind of start at my conclusion, I'm in sort of the same position as Commissioner McGowan. I'm not sure what the best path forward is at this point in time. And part of that conclusion is, regardless of the option that is selected, regardless of how we move forward, I'm still going to have that same concern with respect to an asset retirement plan. Every option that's provided under our financial assurance rules requires an asset retirement plan, requires the operator to say, here's how we propose retiring our assets over time, given these different aspects, given the age of the infrastructure, given what wells are low producing, what wells are shut in currently, et cetera. And we have some information about what wells are shut in and what wells are low producing here, but there's no real tie-in into what that trigger is. And for me, it doesn't matter which option we go for, we're still going to have Evergreen come back and provide us more information with respect to that. And so I think that where I would come down in this is, as Commissioner McGowan said, I don't really want to continue this again. I don't want to push this off, but especially given some of the testimony we also heard from Assistant Director Cuthbertson here, it's not that the trust fund option would be impossible. I think there's some miscommunication there. I think it's appropriate to have a continuance of this to allow, one, the asset retirement plan to be fleshed out more. And I think two, to be able to go back and look at this potential trust fund option as well, to say, hey, we're going to cover blanket amounts as well as move forward. I think in response to one thing that Commissioner Ackerman said, the blanket bond amounts are less in that, and I agree. Without passing judgment on whether the blanket bond amount is appropriate or not, understanding that it wouldn't cover even those direct costs, I think that's part of the idea, is that where it's covered by a blanket bond, these wells presumably are not at risk of becoming wells that need to be plugged and abandoned in the near future, that are not at risk of being shut down. These are wells that are well within their economically producing wells, and therefore you don't need a full amount of financial assurance for those. So some percentage of that blanket bond is appropriate. We don't need to have the full amount necessary at that point in time. Again, I'm not going to pass judgment at this point in time on whether that amount is accurate or not, but I do think it's appropriate to say that blanket bond only needs to be a percentage of what it would actually cost for the plug and abandonment and the reclamation needs. But long story short, I think it's appropriate to have a continuance here, because regardless, I think we're going to need some additional information on the asset retirement plan. And I also think that it'd be beneficial for everyone to get a little bit more information with respect to how this trust plan could also work.
Thank you, Commissioner Cross. Thank you, commissioners, for the initial deliberative thoughts. Commissioner Cross, I'm in agreement with you. I think that it seems like there's uniformity or mostly consensus that this operator should qualify for an option 5 approach. I think that there needs to be further development of the asset retirement plan and the triggers, as you point out, and further development with a trust fund approach as well. I'm wondering, though, if, and I want to sort of frame my deliberative thoughts, is that this is not a win-lose scenario, right? What we're trying to do is create financial assurances for each operator that assure us that they have an ability to meet all their financial obligations. And so I'm not of the opinion that there's a requirement that we pivot directly to option 2, which we, at least some of us, believe isn't necessarily applicable to this unique asset scenario that we have with this operator. AG Davenport, if you could show up, I have a question for you. There seems to be some inability of the operator and staff to try to, get to sort of consensus with regard to option 5. The commission created option 5. It's our thing that we created. And I think it makes it difficult for staff and operators, and I'm not blaming anybody here. I just think that we've created a kind of a subjective approach. Is there any opportunity for me to assign Commissioner Cross to have further discussions with the operator to try to get to a point that we think could be approvable from us? And I'm speaking way out of school. I just have this conundrum that, we had the first hearing and then we waited 6 months, and staff and the operator weren't able to sort of get to an agreement. And I'm just wondering if, since this is option 5 was created by commission, can commission take a little more ownership of it?
Well, I think the answer is yes, Chair. With there, obviously, these with just one commissioner involved, and that's what I'd recommend, is we stick to just one commissioner having these conversations. And recognizing this is a different situation because the commission has already, as a whole, kind of provided some direction on what they'd like to see. So I think it's possible. If that's the commission's pleasure to have a commissioner work through a plan that has already been presented to the commission, to get to a point where maybe the entire commission could approve it. So the short, sorry, I'm running a little long here. The short answer is I think yes.
All right, well, I mean, this is, trying to come forward with a plan that might achieve the greatest likelihood of success. And Commissioner Cross, I'm putting you on the spot, but I appreciate some of your deliberative thoughts about the reason for a continuance. So commissioners, I throw that out there as yet another idea for moving forward with the continuance on that front. Commissioner Messner, I'm going to recognize you, and I know you want to deny it and make it an option 2. So
that's actually not accurate.
oh, good.
My point
Okay.
is that you have to react to the application that's in front of you. And in lieu of option 5 application being approved, then I do believe our rules go to a default option 2. And so that doesn't preclude an operator from proposing another option 5 plan or modifying their plan and bringing it in front of us. But I do believe that we have to react to the plan that's provided to us. So my recommendation was to essentially just go to the default in lieu of being able to approve the option 5 plan that's in front of us. Now, if this operator came in front of us and proposed what I'm hearing, at least from some commissioners, is a modified option 3 plan, which is really evaluating the single well financial assurance and the demonstrated cost and utilizing the structure of a 10-year sinking fund or something of that structure, then I think the operator could propose that even with a denial of the existing proposed option 5, because it seems to me like we have to take action on the proposed plan in order for that to give the operator the ability to provide an alternative plan. And so I appreciate your attempts at finding a creative solution. I do think that there are creative solutions here, and I think an option 3, modified option 3 as approaching a way of approaching an option 5 may be an appropriate way. Creates more flexibility than using option 2 as a default. I certainly believe that. And so anyway, that's my thoughts. I don't think it's inappropriate. I guess I hate to see a commissioner have the burden of having to craft the plan. I think that burden still needs to lie with the operator. But I think that there is a path forward here in an option 5. I'm just not seeing it with this plan.
All right. No, appreciate those comments. Others with comments as we think through this deliberative approach. I sort of remain in favor of this concept of, potentially assigning Commissioner Cross, if you're okay with it, with an opportunity to see what can be further developed. You would bring to the table some of the commissioner's thoughts and process and places in which there, continue to be some absences of information that we think are necessary. Commissioner Cross, Ackerman, McGowan, thoughts? Commissioner Cross?
Thank you, Mr. Chair. I'll just start off saying I'm happy to take on that responsibility. Yeah, I'll leave it there. I'm happy to take on that responsibility.
Commissioner McGowan?
I'm happy for Commissioner Cross to also take on that responsibility. If it helps us get to a good point, I'm supportive. And if Commissioner Cross is willing, I think this is potentially a good path forward for all of us.
Commissioner Ackerman?
Thank you, Mr. Chair. And I wanted to note I don't want to say frustration. I think this operator and its counsel has reported itself very well in this discussion, but I want to note that there's a bit of sausage making taking place here, and I appreciate the operator engaging in this. I do think there's a path forward Again, I note the unique nature of this operator, and I would hope that the operator will continue forward, and know that they will in good faith, but hope they will continue forward patiently in understanding that this is a subjective approach and therefore requires a significant amount more discussion than maybe a standard approach. And I'm in support, Mr. Chair, of your proposal.
All right. I think we have done a fairly good job of deliberating on not a unique operator and approach here. Mr. Lepore, I see that you've daylighted yourself. Did you have any final comments?
I didn't mean to daylight myself, I don't think. I don't. I feel I should defer to my client. I appreciate the commissioner's comments. I appreciate Commissioner Cross's willingness to pursue this as you have recommended. I appreciate Commissioner McGowan's support for Commissioner Cross to do that. And I very much appreciate Commissioner Ackerman's comments. And I think my client will be inclined to agree, but he can speak for himself if he wants, or we can maybe ask for a little recess to discuss it.
Mr. Joy?
Thank you, Mr. Chairman. Evergreen doesn't need a recess for this. I am deeply appreciative of Commissioner Cross willing to take this on through, I think, every step of the process. Evergreen has been willing to and is trying, both in good faith and in earnest, to reach an acceptable, appropriate, necessary, reasonable plan. As you commented, this is a little bit of the sausage making exercise, and there is a certain amount of frustration on the operator's perspective, because there does seem to be a bit of a shifting playing field. I understand why that's the case. It's nevertheless, it's there. And so we're very, very happy to work with Commissioner Cross to come up with something. As I said, we've been supportive of the trust approach and the retirement account creation approach all along. We've been supportive of the process of getting to demonstrated costs. We're supportive of working through and understanding what an asset retirement plan in the view of the commissioners appropriately looks like. I think we can find solutions to all of those things. And I think this is a great way to do it.
All right, thank you very much. AG Davenport, maybe hear me out here. I would move to continue this application to an indefinite date for us to reconsider it, with direction to the applicant that Commissioner Cross will insert himself into helping work through the issues as identified by the commissioners today in deliberations. I would add to that motion that I don't really want this to take 6 months again, and I would like this to be brought back to us in an expeditious timeframe as possible. And I would note in my motion that this is not meant to disallow Commissioner Cross from being a deliberative commissioner once this comes back to us. That was a mouthful. AG Davenport, anything you want to correct the record on?
Thank you, Chair. If I may, I might suggest one modification, and that is a continuance until Commissioner Cross reports to the commission as a whole that the financial assurance plan is ready for commission consideration. So still not a date certain.
Sure. Okay. The motion is so eloquently modified by AG Davenport. Do we have a second?
I'll second.
Motion and a second. Is there further deliberation, discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Aye. Any opposed? All right, motion carries. You gentlemen have some work ahead of you. We look forward to hearing successful work back to us as soon as you can get to it. And thank you, Commissioner Cross, for being voluntold to do this. We really appreciate your willingness there. All
Thank you,
right.
Mr. Chair.
We've got another matter to come before us. Let's take 10 minutes and let's return at noon. Commissioner McGowan.
Thank you, Mr. Chair. I'm going to need till about 12:20. I have a call at noon related to biochar with Representative McCormick that should last no longer than 20 minutes, starts at noon.
Do you want 12:30? Just, and then we
Sure,
can just kind
yeah.
of like call it a lunch break kind of thing?
Yep, I appreciate it. Thank you.
Okay, Commissioner Cross.
I'll just note, my wife is traveling, so I need probably 20 minutes or so around the 1 o'clock hour just to move my son from therapy.
All right. This may not be a long one. Let's try to return at 12:30. And if it turns out that it's longer than that, we'll take a break at 1. All right. So returning at 12:30 to take up docket 2309000283. Thanks, everybody. All right. Good afternoon. We're going to continue the Energy and Carbon Management Commission hearing. We will now take up docket 2309000283, an oil and gas development plan. The applicant is Verdad Resources. I don't see Commissioner McGowan yet, but we could go ahead and take care of swearing in of the witnesses, Mr. Prashala, if that's okay with you.
That works for me, Mr. Chair.
AAG Mercer, it looks like we've got 2 witnesses. Now 3.
Thank you, Mr. Chair. Mr. Prashala, are the 3 witnesses on the screen the entire panel?
They are. Thank you.
Okay, wonderful. Well, good afternoon, folks. I'll just go one at a time and ask that you raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Ms. Mitchell.
I swear to tell the truth.
Thank you. And your name for the record?
Heather Mitchell.
Thank you. Mr. Cognetti?
My name is Mike Cognetti, and I swear to tell the truth.
Thank you. Mr. Berghorn?
My name is Jeff Berghorn, and I swear to tell the truth.
Thank you very much.
All right, with the procedural matters out of the way, we will take in order initial statement from Jason Maxey from Weld County, followed by the Verdad presentation. Mr. Maxey, you are recognized.
Thank you, Chair Robbins, and good afternoon to you and the commissioners, fellow commissioners, and the applicant. We always appreciate taking a few minutes to speak regarding the Weld County 1041 WOGLA process, and in this item here before you, specifically Verdad Resources Hill 2527 location. Our Oil and Gas Energy Department held our standard pre-application meeting for this location on January 25th of last year, 2023. At that time, several alternative sites were discussed per our normal process. Attendees not only included Weld County staff and Verdad Resources staff, but also ECMC staff was present and BLM staff was present. CPW and CDPHE were invited, but unfortunately were not able to attend. However, regardless of that, as per our standard practice, all attendees and invitees to our pre-application meeting, they do all receive copies of the official meeting notes from those pre-app meetings. We've assigned our standard 1041 WOGLA number to this location. That is, for the record, 23-0036. We received the initial application on September 13th of 2023. And after some discussions with Verdad staff and my staff to clarify and enhance certain application items, we received the final application version on October 11th, 2023. The application for us did include an analysis of 5 alternative sites, which were reviewed and discussed in detail with our staff. Based on CPW on-site consultation, however, Verdad considered an additional 2 alternative sites. And at our 1041 WOGLA hearing, the Weld County hearing officer reviewed and discussed all 7 of those alternative sites with the applicant. And the Hill location was the one that was moved forward with due to it being determined to be the best location. There are no Weld County defined building units within the 1041 WOGLA zone. We did send notice of our hearing to 5 individual property owners. We did receive 1 phone call from a notice party regarding this application. However, my staff answered that person's call and their questions, which were specifically regarding noise. And there were no further questions from that individual. We also did not receive any requests to participate in our hearing. We did send out referral requests to multiple agencies on November 1st of last year. We received a lot of responses back. We just didn't get one from the school district or from the BLM, but that is fairly standard within our process as well. If the school districts don't have any concerns with traffic routes or any homes nearby with school bus stops, a lot of times they don't reply to our referral. Our hearing was on January 11th of 2024. However, due to the applicant being ill, we pushed that back a week, and so it was actually heard on January 18th. And at that hearing, our hearing officer considered testimony, found the application to be compliant with Weld County Code, and subsequently approved the permit. No referral parties participated in our hearing either. Our final order was recorded as per our process on January 22nd, 2024, and then published in the Greeley Tribune on January 26th. We believe from a land use perspective, this is a good location. It's very remote. It's very close to a established county road, which is subsequently very close to a state highway for traffic purposes. We submitted our 2A comments to the ECMC on February 23rd, and they should be included in the director's recommendation. We have read we've received and we have read the director's recommendation, and we do support approval as permit. So I will remain on the call if need be for any questions, but I appreciate the time to say a few words about it. Thank you.
Thank you, Mr. Maxey. Appreciate you being with us as always. Any questions for Mr. Maxey? All right, thanks for sticking around. If we have questions, we'll let you know.
Thank you, sir.
Mr. Pershala, the floor, the video is yours.
Wonderful. Thank you. Good afternoon, Mr. Chair and Commissioners. And I do realize that you've had a long morning and that Commissioner Cross is under some time considerations. So I will endeavor to be quick with my remarks. For the record, my name is Joe Pershala with Wellborn Sullivan Meckin Tooley. I represent Verdad Resources, LLC, and am pleased to present the Hill 2527 Oil and Gas Development Plan. First, I'd like to thank Director Murphy and staff for their work on this application, as well as Mr. Maxey and Weld County's work and his comments in support of the application. Presenting for today for Verdad is Heather Mitchell, Verdad's regulatory manager, and also available for questions are Mike Cognetti, Director of EHS&R, and Jeff Berghorn, Land Manager. Verdad's application requests the Commission approve an oil and gas development plan covering approximately 1,930 acres within Township 8 North, ranges 60 and 61 West in Weld County. The proposed development is planned from one new oil and gas location with a total of 10 horizontal wells. As you heard, Weld County is the relevant local government, which has approved the Hill 2527 pad at 1041 Wogla 23-0036, and there are no proximate local governments. Verdad owns leasehold covering more than 45% of the mineral interests in the proposed drilling and spacing unit, and therefore has the right to develop per Commission rules. And this spacing consists of fee minerals. With regard to the spacing, Verdad is requesting approval of a Rule 305 drilling and spacing unit application, requesting that the Commission establish a 1,920 acre drilling and spacing unit for sections 25, 26, and 27, Township 8 North, range 61 West, with a total of 10 horizontal wells. The application further requests that certain existing spacing units covering portions of the application lands, that those units remain in place until the associated horizontal wells are plugged and abandoned as part of Verdad's oil and gas development plan. Verdad maintains that the proposed spacing unit and proposed boundary setbacks satisfy Rule 305B and the Conservation Act, including the protection of correlative rights. With regard to the location, Verdad is proposing to develop the spacing unit from the Hill 2527 pad, which, as you heard from Mr. Maxey, is in a rural part of Weld County. The pad is approximately 10 acres in size. It's located within Section 30, Township 8 North, Range 60 West, which is adjacent to the mineral development area. The pad is located on fee surface, and Verdad has a surface use agreement with that owner. It is planned to accommodate 10 new 3-mile horizontal wells that will be drilled in an east-to-west orientation. Verdad's site selection focused on avoiding all 304 B2B receptors. However, given all considerations, the proposed siting ultimately could not avoid all receptors and is within high priority habitat for pronghorn, which CPW has not provided a Rule 1202 waiver. Therefore, an alternative location analysis was required and has been conducted, and the Commission's review is under Rule 301A. Verdad evaluated a total of 9 potential alternative locations to determine which location best avoids impacts to public health, safety, and welfare, the environment, and wildlife resources. Following consultation with Weld County, ECMC staff, and CPW, Verdad selected the Hill 2527 pad as the best of the alternatives. It's sited with the agreement of surface owner. There are no human receptors within 2,000 feet. There's no water resource receptors or water resource concerns. The location is immediately adjacent to roads, which minimizes new access road construction and minimizes impacts to the high priority habitat. The location is sited close to existing pipeline infrastructure to minimize new right-of-way disturbance. The location is sited outside the Pawnee National Grasslands, which are very nearby these lands. And the location is sited at the very edge of that HPH boundary. And as noted by CPW in the Form 2A, quote, CPW views this OGDP as a prime example of how to site a new location within an HPH, e.g. next to an intersection with existing pipeline infrastructure, close quote. As you will hear, Verdad will deploy a suite of best management practices at the location that will further minimize and mitigate impacts. BMP highlights include 3-phase pipeline infrastructure that's for oil, gas, and produced water, thereby eliminating takeaway associated traffic impacts, which is especially important given the HPH considerations. It will utilize electrified production equipment, minimizing emissions, employing a tank vapor recovery design to minimize emissions, employ continuous emissions monitoring during all phases of development to further mitigate air impacts. The operations will be conducted outside the sensitive winter season for pronghorn, thereby minimizing impacts to wildlife. And Verdad will pay approximately $70,000 for direct and indirect wildlife compensatory mitigation. Moreover, Verdad's Hill 2527 OGDP will provide cumulative impacts reduction, as it will allow for the plugging and abandonment of 6 wells and the closure of 3 oil and gas locations, resulting in a net decrease of Verdad's emissions in the oil and gas development area. With regard to notice, Verdad has given proper notice pursuant to Rules 514A and 303E1, and no petitions or interventions were received. On March 27, 2024, the Director issued her recommendation that states the Director has found the application complies with all Commission rules and does recommend approval. Verdad maintains that this application satisfies the Conservation Act and all Commission rules, specifically Rule 301A, with a very thoughtfully selected location and operations that do prioritize the avoidance of adverse impacts, avoidance of human receptors, cited in coordination with CPW to best minimize impacts to HPH, minimizes access road disturbance, utilizes 3-phase pipeline takeaway to minimize and mitigate emissions, traffic, and new disturbance, and mitigates impacts by closing and reclaiming 3 other locations and the plugging of 6 wells associated therewith for a decrease in emissions. Verdad respectfully requests that the Commission find that this application satisfies Rule 301A, adopt the Director recommendation, and approve the application. And with that, I thank you for your time and consideration of Verdad's application, and I will pass this presentation to Ms. Mitchell.
Thank you. Are we still good on time, or just wanted to make sure? Okay, I'm gonna share my screen. And I'm gonna find my pointer. Here we go. Okay. Good afternoon. I am Heather Mitchell. I'm the Regulatory Manager for Verdad Resources, and I'm here today to talk about our Hill 2527 Oil and Gas Development Plan. As Joe mentioned, we also have Mike Cognetti and Jeff Berghorn here on the line to help answer questions after the presentation. So today I'll go over briefly our proposed location and development plan, alternatives, best management practices, benefits of the development, as well as permitting and operational timelines. This first slide shows our proposed Hill 2527 location. If I can get this pointer here. Oh, I need it to be the laser pointer. Here we go. Starting here, this is our proposed Hill pad. It is a 10-acre location located in the northwest of Section 30, Township 8 North, 60 West, and it will develop the sections 25, 26, and 27 of 8 North, 61 West. Here you can see that we are just south of Highway 14, as well as east of Weld County Road 97. Our access road is 0.14 acres. It's very close. And also on this slide, you can see, this isn't my laser pointer, but this pink line is an existing gas line, and this bluish line is an existing oil and water line. And as a company that doesn't operate our own midstream, the best way for us to mitigate any risk of not connecting is to site our location as close to these lines as possible. And we were able to do that in this application. You can see here, we're at the edge of high priority habitat. We're sited greater than 3,000 feet away from the nearest RBU. We are within Weld County Ag Rural Planning Area, and we cited this in consultation with the surface owner. This is our proposed development plan for the Hill 2527. We will be drilling 10 3-mile laterals east to west, and we'll develop the Niobrara, Fort Hays, Codell, and Carlisle formations. This slide orients you to our location within Weld County, as well as identifies 304B2B receptors. Here you can see our proposed pad in the middle of a 2.5-mile radius, and we have our unit outlined in red. These diamonds are residential building units within the area, and then you can see the outline of the high priority habitat for the pronghorn winter concentration area. As far as receptors go, our nearest RBU is 3,010 feet to the south. We are not within a mile of any schools or childcare facilities, outside activity areas. Our nearest municipality is 14 miles to the southwest. It is the town of New Raymer, and we're not within any disproportionately impacted communities. We didn't trigger any of the water receptors for this particular location, but as you can clearly see, we are located within high priority habitat. We did get an SUA for this location, and we aren't asking for any 604 setback variances. This slide goes over all of our alternatives that we reviewed for this application. And just to kind of orient you to some of the information on this slide, each proposed alternative has a 2,000-foot radius around it. We also made the RBUs a little bit bigger just so you could see them on the slide presentation. As always, we look at what is existing within our unit, and those are highlighted in green. They also have the wells identified here in white. Those will be plugged as part of this development, and they show you where they're located. Newer alternatives are in purple, and our proposed location is in blue. Again, we also show the existing gas line as well as the existing oil and water line that are located just near our pad. And we have the yellow highlighted high priority habitat, and we also highlighted in this green hatch Pawnee National Grassland. We spoke with them, and so we only highlight 2 alternatives, but after talking with the Forest Service, we eliminated any alternative that would have been within high priority habitat. So scooting along. We sort of grouped these into 2, starting with the west side and why we ruled them out. Generally on the west side of the habitat where we have the west side of the unit where we have existing pads, we will be plugging those wells, and we'll have to work around the plugged wells. So we would be adding additional acreage equal to or approximately equal to a new pad. And we will also, all of them are further into the high priority habitat, as well as further away from oil and water. And then I'll go through them quickly one by one. This first location is our Speaker 27861 location. This has 3 existing wells that are planned to be plugged, and we would have to work around those wells and add additional acreage to develop this unit. It is deeper into the habitat, and it is also further away from oil, water, and gas lines. And it's probably hard to see, but the way CDOT works, you have to access from only one point of the parcel, and the access point is from our other location. So we have a long access road here, which is not ideal. Our next existing pad is our Speaker 127-31-861 pad. This has 2 existing wells on it that we plan to plug. It would require additional acreage to develop the unit. It is deeper into the habitat, and it has longer builds for oil, gas, and water. And then in addition to that, we have an RBU just to the northwest that is within 2,000 feet. The last pad that we examined within the unit that was existing is our Orlando Hill 26-44-861 pad. This has 1 existing well that is planned to be plugged. It is deeper into the habitat. It is has longer build for oil and for water. It is also in the center of the unit. And when we place a pad in the center of the unit, it means additional wells and additional disturbance time lanes to drill both east and west. This surface owner is the same surface owner as our proposed our proposed hill location, and she preferred the new location. This location is closer to her home. We also looked at some new pads on the western side of the unit. This particular location is on the far west side in section 28. It is deeper into the habitat, further away from oil, gas, and water. And then in addition to that, CPW likes you to be close up to existing disturbances. In this case, we're pretty far away from the highway, so we'd need a longer access road, and we're not up against any disturbance, really. And the last location we looked at on the western side of the unit is in section 23. This is deeper into the habitat. It is closer to surface water. It is also, although the RBU is greater than 2,000 feet, that RBU distance is closer than our proposed hill pad. In addition, this one is longer oil and water builds, and it is also in the center of the unit, requiring us to drill both east and west, and that adds wells and time. So then we looked at the eastern side of the unit, where we were closer to our proposed oil and gas lines. However, the primary reason we ruled out a lot of these alternatives are because we either were unable to obtain an SUA, or it was located on Pawnee National Grassland. We spoke with the Forest Service related to this particular area in general, and when I spoke with, his name is Vern Kohler, he talked about this being some of the last remaining undisturbed contiguous Pawnee National Grassland. And it supports a number of species, including prairie dogs, burrowing owls, and mountain plover. He preferred our proposed location because it had been previously tilled and disturbed, whereas this area is generally undisturbed. So we opted to not site on Pawnee National Grassland. So just quickly going through some of our alternatives. This particular alternative is just outside of high priority habitat. And it is south of Highway 14. Here we were unable to secure an SUA, but we are also only up against 1 disturbance, and we're closer to water. And then our next alternative is just north of that, also outside of high priority habitat. However, this is close to a playa, which is poor for construction. Everything kind of slopes towards that direction. Also this is located, although outside of high priority habitat, it is on undisturbed Pawnee National Grassland. And it again supports those other species. This particular location is catty corner to our proposed hill location. Here we are closer to surface water, slightly deeper into the habitat, and we were also unable to get an SUA here. The last alternative that we looked at for this application is just north of our proposed location. It has a lot of the same benefits. However, it is not only within high priority habitat, but it is also on Pawnee National Grassland. And so we opted to not site here. Kind of zooming into our, this is our production pad after interruptible reclamation. Some of the mitigation measures that we will implement specifically to help with wildlife are avoidance of operations during the sensitive timing for the pronghorn winter concentration, which is January 1st through April 30th. We will pay both compensatory mitigation for direct and indirect impacts. We are also, our proposed pad and access road are less than 11 acres of disturbance, which you get a little discount from CPW when you're able to keep your disturbance under 11 acres. We're sited near oil and gas and water lines, which will reduce truck traffic as well as emissions. We also sited our production equipment to the north, so we're able to reclaim further into the habitat away from our existing disturbance. We will use CPW recommended fencing and seed mix for this location. Other BMPs worth noting here, we have 2 slides. I'll just call out a couple of them. We have a drill rig that is powered by natural gas generators with battery backup. We have a frac fleet powered by electricity generated by natural gas powered engines. Our production equipment is electrified through grid power for the VRUs, gas lift compressors, and instrument air. We plan to have sound walls on the north, west, and south side of the pad. We are sited away from RVUs and high priority habitat. Other things of note, we have this pad is designed for detention per Weld County. We have robust inspection protocols, remote shut-in capabilities, and we'll have oil, gas, and water takeaway here prior to production. This slide represents the benefits of this particular development. Here we plan to plug 6 existing wells within the unit. As part of that, we'll be decommissioning those pads. So 7 acres of land will be reclaimed and returned to the surface owners and to the high priority habitat. We have 14 oil tanks and 6 water tanks that will be removed, 1 gas lift compressor engine, and a number of pumper truck trips will be eliminated per year. And then this slide goes over the total estimated reduction of the combined 3 locations, and a proposed estimate of hill emissions. And our hill emissions will be less than what we will be taking off the books. We'll have about 0.97 tons per year of NOx removed, 1.17 tons per year of CO removed, and 0.79 tons per year of VOC removed from the books. Just going through our timeline, which has been mentioned a couple of times, but we did have our Weld County pre-meeting in January of 2023, and then we met on site with CPW on March 1st of 2023. After that, we reviewed a few more alternatives with ECMC and CPW on April 3rd, a year ago. After we felt confident that we had the right location, we signed our SUA and sent out pre-application notices on May 16th. From that, we did hear from our residential building unit owner to the south, and they requested sound walls and some specific baseline water sampling, which we will accommodate. We submitted our applications in September, and we did get approval through hearing in January for the WOGLA, and we passed OGDP completeness also in January of 2024. We had one more meeting with CPW and ECMC just to clarify truck traffic and give a little more information per Brandon's request. And after that time, he said that he felt like how we had cited our location is how you should cite a location within high priority habitat. And he gave his approval. And then we received our director recommendation on March 27th, 2024. And we're here today. Upon approval of this application, we will be filing permits in Q2 of 2024, as well as building the pad and paying CPW our mitigation fees. Q3 of 2024, we will drill the production strings and conduct some offset work. And then we'll come back Q2 of 2025 and plug the existing wells, as well as do our completion, drill out, and flowback operations to have our wells flowing by Q3 of 25, sorry. Lastly, this is just a conclusion of how our proposed location minimizes adverse impacts by not being sited near any RBUs, schools, or childcare facilities, or disproportionately impacted communities. We have no water resources in the vicinity. We're located near 2 existing access roads, as well as existing pipeline infrastructure. We'll have oil, gas, and water takeaway. We're able to develop this unit with 1 location, and we're sited at the edge of high priority habitat. In addition, we will be operating outside of the sensitive timing for winter season for the pronghorn. We will pay direct and indirect compensatory mitigation fees for this location. And just calling it out one more time, that CPW views this OGDP as a prime example of how to site a new location within high priority habitat, and that is within the 2A comments. In addition to that, we'll be plugging and abandoning 6 wells and decommissioning 3 pads, returning 7 acres of land, and removing a number of tanks and pumper truck trips, as well as measurable reductions to NOx, CO, and VOCs. That's all I have today, and we are happy to take any questions. We very much appreciate your time and your review of this application.
All right, thank you very much. Commissioners, questions for the applicant? Commissioner McGowan?
Thank you, Chair. I actually had no questions. This is one of the few applications that I didn't have to meet with OGLA staff and ask for clarifications. I thought it was well thought out. I think you've demonstrated very well our hierarchy of trying to avoid first and then minimize and mitigate. I appreciate the fact that we're piping all liquids, minimizing impact, peeing and A-ing wells, coming up with some beneficial offsets. I thought this was a nice application, and I appreciate the way that the operator put it together, and I don't need to deliberate. I thought this was well laid out.
Agreed. Further questions, comments, deliberations from the panel or from the commission? Do we have a motion?
I'd move to approve.
Second.
Motion and a second to approve. Any further discussion on the motion? Seeing none, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Great. Thank you very much. We do appreciate the presentation.
Thank you, commissioners.
Thank you.
Commissioners, that brings us to the conclusion of our agenda. I did want to make a comment for the public at large and for our cumulative impact rulemaking as well, as I commented last week. Last week, I informed our stakeholders and the public that legislators and stakeholders were having discussions that could impact the scope and timing of the cumulative impacts rulemaking. Those discussions are still going on, and so I do not believe that it would be in the best use of everyone's time, stakeholders, the public, staff, and the commission, to have a public comment session on the cumulative impacts rulemaking on April 9th. Next week, when we open the rulemaking hearing for public comment, I, as one commissioner, plan to immediately move to continue that hearing. The commission will need to approve any motion, so the hearing is not continued yet, but I wanted to give everyone as much notice as possible of this plan. I think that's in the best interest of everyone. I've talked with some of our cumulative impact stakeholders, and they are in agreement. As I mentioned earlier, if for some reason we do not end up with a new definition around cumulative impacts, we will rearrange the cumulative impacts rulemaking in a manner to ensure that it is held as promptly as possible. but also in a manner that ensures all parties have the ability to be fully ready and prepared to discuss with us cumulative impacts. That might mean that we would open the hearing before the April 28th deadline. That might also mean that we won't actually meet the 28th deadline, but we should be able to be successful shortly thereafter with regard to cumulative impacts. If a definition is foisted upon us that is new, then we would ostensibly need to not move forward with the current cumulative impacts rulemaking and then talk with stakeholders about the appropriate timing for that. So those are just some thoughts generally to get out there to our stakeholders. I would ask the hearing officer to sort of translate that into something that gets emailed out to folks. We're trying to balance a tricky situation here. It's not any of our doings or undoings, but we're doing our best to try to accommodate all the various perspectives that are important to this topic. Commissioners, do you have any questions for me or any thoughts further along those lines? All right, then hearings, well, to someone at staff, please have the hearings officer sort of translate that into an email out to everybody. With that, we have concluded our business of the day. I would move to adjourn.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Good work today, guys. We are adjourned. We'll see you later.